So let's call the meeting to order. Cell phones are silenced.
Can I ask a time check since I turned off my phone?
It's 8 o'clock.
Thank you.
Rise for the pledge, please. Pledge allegiance to the
flag
flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
God give us the gun.
Yeah.
So good morning.
Good morning.
Josh, can you hear me?
Yep, loud and clear.
Great. So how many people do we have as our virtual guests this morning?
We've got 22 at this point.
Fantastic.
Thank you.
Okay, excellent. Step one is approval of the agenda.
I move to amend the agenda.
Is there a second?
I second.
All in favor?
Aye.
Okay,
The specific amendment that I would like to make is, and I passed out a package to each board member, is for motion to define director qualification in bylaw section 5.01 to 5.02. We'll substitute the handout for the motion that's in the package. It's minor wording changes to replace something called record owner with owner of record.
okay, so you're moving to make that change?
Yes, to
Is there a
insert this in
second?
the package.
Is there a second to that change?
Second.
All in favor?
Aye.
Aye.
And a motion to accept the agenda as amended?
Second is to add the wording and to conduct such referendum to each and every motion in this package.
Okay, is there a motion to approve both those changes?
So moved.
Second,
Second.
all in favor?
Aye.
Aye.
So the amended agenda is approved. Okay, so I want to first thank the staff who supported this meeting. Secondly, I'd like to thank everybody who came here, all the guests that are here virtually and who got out of their jammies and came here in person to join us.
God bless you.
Yes. I appreciate your interest in the activity we're going to engage in today. It's an important step in the process of doing revisions to our bylaws. The bylaws have not been revised since 2008, so we have received advice from council over the years and from other sources that our bylaws need to be reviewed and updates are needed for clarification purposes and also any policy changes that are needed. So this is the first step in a process. I want everybody to understand that. Today, we are going to consider a number of motions, some of which will move to create language for a referendum to change wording, to clarify wording in our bylaws, and some will move to create language that actually changes some policies in our bylaws. And so at this step, any of the motions that survive the vote process today, any that receive majority vote by the board, will go to the second step. The second step is a town hall meeting. Well, actually, the second step will be for the actual wording for the referendum questions to be created. And the next step after that is a town hall meeting where we will be able to dialogue with the membership regarding these various changes. Today, we'll hear public comments from those of you who wish to speak. This will not be a dialogue process. It will be a process of hearing from you what your thoughts are on the process and on the content of these motions. And any other comments you have regarding the bylaws. This being a special meeting, comments will be confined to bylaws issues only. Any other issues you can save for the regular meeting, which is going to be held later this month. The final step in the process after the town hall meeting is for a referendum to go out to the membership. And that referendum will contain the wording changes, each section of wording change that passes the motion process today. And so it will be in the hands of the voters as to which of these wording changes and policy changes actually go into effect. In that referendum process, the majority vote carries the approval of the language. So again, I appreciate your participation in this meeting as part of your process of educating yourself in preparation for the referendum vote on the policy changes. So thank you. And public comments, people wishing to make public comments, please state your name and address. The time limit for public comments is 5 minutes for our bylaws. The order for the comments in this hybrid meeting platform is: first, we will hear from members who are physically in attendance. Second, MS Teams participants. The MS Teams participants are asked to use the raised hand function to gain the floor. Josh will be moderating that. And third, any members participating through the MSN call-in only function, those will also be moderated by Josh. And then fourth, members wishing to speak via the MS Teams chat function, Josh will be moderating that as well. All other comments in the chat function will be considered out of order, as will be speaking during the meeting without being given the floor by the chair. So let's move on to new business. Step one, we have a motion here to, I'm sorry, public comments. I asked for them and I didn't give you a chance. Anybody have public comments? Yes, ma'am.
I don't know.
Your name and your
Okay.
address, please.
Dulcie Alexo, 22 Canal Road. And I apologize if this is not the forum to address this, okay? So let me know if I'm out of line. I've never been to one of these meetings, but the reason I'm here is because I live at the corner of 22 Canal Road and Burnt Hill. Behind me are hoarders.
Okay, that would be out of order for today. Today, we're speaking only about bylaws changes.
Well, this
and the
would be a
bylaws.
bylaw change. I mean,
Okay,
having
if it
people-
is.
Okay, so my statement is that on the whole, you all do a great job. But I think bylaws need to be changed as far as property maintenance. If you saw what I have to look at every day, you'd probably be sick to your stomach. Now,
Okay,
I
ma'am,
want,
I'm going to just comment. The regulations regarding property maintenance are part of our book of resolutions.
okay,
That goes beyond the scope of the bylaws.
okay.
And so please come to our regular meeting. I think it's the
I'm sorry.
23rd.
I'm sorry, I didn't know.
No, you're
Yeah,
good.
I understand. Yeah. But today we have a lot of bylaws to get through. It's going to be a lengthy meeting.
Okay.
And so we welcome you definitely to come and speak at the
When's the
regular
next
meeting.
meeting?
I think it's the 23rd. 23rd.
At what time?
It's at 11 a.m. It's in the clubhouse
Okay.
and it's also virtual.
Okay.
So
All right.
thank you.
I'm sorry to take up your time.
No
but
worries.
Oh, thanks
I
for
apologize.
stopping.
Feel
Don't
free
ever.
to email me with your issue and I will respond back to you and prepare for the meeting.
So are you Josh?
I'm
Frank
Frank Daly.
Daly.
Frank Daly.
Or just directors@oceanpines.org
Okay.
and it will come to all
And
of
because
us.
I've emailed before and I haven't gotten a response, so
You'll get a response. Thank you.
Thank you for
All right,
coming.
thank you,
Thank you.
everybody. I'm sorry.
No worries.
Thank
Have a good day.
Any other public comments in the room? Yes, sir. Your name and
Tom
property.
Schwartz, 198 Ocean Parkway.
Thank you.
Do I need to face the camera or something, or just
If you choose
talk from
to,
here?
you just talk.
Oh, okay. I didn't know.
What was your address again? I'm sorry. I was.
198
Thank you, sir.
Ocean Parkway, just literally across the street,
Thank you.
the good section. I'm just kidding.
Room for one more?
Yes, sir.
Couple of comments this morning. Good morning to start with. Just an overhead comment to the bylaws committee. I don't see the guy that's.
The chair is here.
Oh, there he is. Okay. Thank you to their diligence in going through, trying to clean up things and bring things contemporarily to the forefront, which I wish them well and continue to get this process done. On the board proposals that were added, now there's like 30 some pages in the docket, and I've spent a considerable amount of time, trying to go through each one of them and look at them, and most of them are editorial changes that there's only a few substantive things in the cleanup. However, the proposals that are coming from the board, there's a couple that are specifically I need to mention. The years as owner / in the DRs and the equitable owner, owner of record or whatever that'll come out in the language. It looks to be 3 years is the proposal, that you have to be in or own a property for 3 years. And then there's an exclusion if you're a committee member for at least a year that you could run without having the 3 years, of owner. That part of the committee, being a committee member.
Excuse me, would the people who are virtually attending please mute your microphones? The sound is coming through into our room.
No.
Okay.
Sir, please continue.
Okay. The committee member addition to the eligibility for 3 should be taken out. That's just looking for trouble with people trying to bid themselves onto a committee to get eligibility. And it's like the good old boy kind of club that will put you on this committee and then groom you for something down the road. The actual eligibility, why not make it 10 years? Where did 3 years come from? So I have a real problem with 3 years, and here's the reason why. The MLS listing for the last 3 years, from 2019 to December 31st, was over 1,500 changes in ownership. If you assume that at least one person did the mortgage, possibly 2, which would be a spouse or a partner, that's 3,000 people that are going to be disenfranchised from the eligibility of running. And that doesn't include estate sales and sale by owner. That's just what's on record. That came from MLS service. And I think this just really need to think that through, because it doesn't say continuous time, or is it cumulative time? I've lived here before and I've come back. Well, I haven't been back 3 years. Do I get excluded? But yet I've been here before. So there's a lot of, that just needs to be struck. It just simply needs to be taken out. Because you're disenfranchising a whole lot of people, not just a few. 1,500 people plus a spouse, potentially 2,500 people, maybe even 3,000 that could possibly be eligible. And again, we have over 8,500 numerical lots. And I included the 60 that are being built by Steen down off of King Richard. So we're over 8,500 numerical lots. And if we're really looking at it, that is just a tremendous amount of people being excluded, and we want more participation. So that is a specific one. I could go through a lot of other little ones, but I really believe and trust the board and the bylaws committee to flesh out the details on making sure that everything is equal between the charter and the declarations and the bylaws, because the bylaws are on the bottom of the pecking order, and they're supposed to mimic what's already written, and they're only the how to get the organization done, not to structure the organization. So those specific things about the eligibility of the committee member really should be taken out.
Hold on, Pete.
On the face of it. And the final thing, and my time is up, is there is a section in here that deals with a spouse. Totally unacceptable. I don't care what the other person's done. The way it's written, I understand that people are looking for straight up people that, you know, are not thugs. But putting the spouse connection in there, totally unacceptable. It'll go to court. I've said this before back in the other meeting, do the right thing. That's not doing the right thing. That's being, you can't say it's vindictive to an individual, but boy, it really smells funny. So that's it. I appreciate your time and your attention. But I really strongly encourage the bylaws committee and the board to strike that eligibility requirement, go back to the way it was. And the final thing is, I don't think we should be moving this forward until after the new election. Let the people that are going to run for the new board use that as part of the bylaws change and everything else as part of their election process, get a sense of the community at that time, save us money on the referendum cost. And then after the new election, bring forward something that needs to be brought into a referendum with new leadership and a sense of the people. And I appreciate your time. Thank you very much.
Thank you.
Thank you.
Any other comments in the room? Tom?
Tom Janisek, 17 Lookout Point. I apologize for not knowing more detail on this. I just got back. I should have stayed. It's cold here. But I read a few of the articles that you're looking to change, and it strikes me that I sit here across from 33 boards on this wall and pictures, and I would dare to say that of the 7 members, 33 boards, 200 and some odd, whatever, close to 300 members, you would probably alienate over half of them with what you're trying to change now. If we went back and looked at some of them and some of their products and some of the times they were here, there were people that had been here for 1 year. They were some of the most productive board members we ever had back in the day. To go 3 years, why don't we go 10? Well, half of you wouldn't be able to get on the board. That's why we don't go 10. So, and another thing, I find it egregious to go after a spouse when another spouse is running. They don't necessarily do the same job. They don't necessarily, you don't know the circumstances and everything. You're making it so restrictive to become a board member that we already have a hard time getting board members. Last time we only had 3 that ran, 4. I mean, it's so hard to get people to run for this board, and you're going to make it so restrictive that why don't we just have the board pick the new members? I mean, it's just seeming to get to that thing. And this just seems to me, these changes, as I read them, seem vindictive and like you're just trying to get back at the judge, at a judge's decision. They seem ultimately sour grapes and vindictive. I'm sorry, that's just what I read in them. It just doesn't seem like you're doing anything to help the community. If you want to clean up some bylaws, I mean, you've got people to do that. The bylaws committee's been trying to do that for years and doing a great job. But to add these restrictions to homeowners being able to run for the board seems to be it just seems to be sour grapes. I'm sorry, it goes directly at the last election, which we lost in the court of law. We should have walked away from 6 months before, and we didn't. And now we're trying to go, oh, well, you know what? We couldn't win that, but we're going to go ahead and change the bylaws the way we want to. And I totally agree that these changes should not be made with this board. You do not have 7 elected members on this board. You have 2 appointed members. And there are going to be 3 seats run for this board. These bylaw changes should not be made by this board. I mean, there's reasons the public did not get to vote 2 of these members on at all. Nothing personal, really isn't. It's just a simple fact that you want them to be members of a committee. Not all of them have been members of committees. I mean, it just seems to me that this is just trying to get back at the judge's decision, and it's just vindictive and sour grapes. That's all it seems. I haven't had a lot of time to peruse them all, but I know the few that I read in detail, seems like you're just trying to go, you know what? So what you say? I'm going to make it, we're going to fix this on our own. I'm going to go ahead and change everything the way we want it to be so we can pick our own board and make it the way we want it to be. As a good friend of mine once said, if we all thought the same way, we'd only need 1 board member. You want board members with divisive, changing opinions that have different opinions on what's going on. That's the reason you have 7 people on the board. So do what's right for the community, not just for the board members who have an agenda. Please do what's right. Remember, you're working for the community, not for each other. So thank you. That's all I have.
Any other public comments in the room?
Mark,
Sir?
Mark,
We got two.
Yes, sir.
can I go?
Yes.
Sorry. Mark Thomas, 1132 Ocean Parkway. Just the spouse thing, ridiculous. I mean, the president can run, the president of the United States can run as president and his spouse could be a felon. So that makes no sense to me. That seems like you're attacking someone. I don't know who it is, but it's sad. And we've got to get past that. Another thing is, so we lose in court. It's okay, we lost. We won't appeal it. We'll just change the rules. Sounds a little bit like what happened on the 6th. You know, they just said, hey, we're not gonna approve this election. We're just gonna change things. We're gonna do whatever we want to do. We don't need that type of thing in this community. We do need change. And it seems to me the change we're not gonna get because we're eliminating a lot of the pool members who want to be part of the board. So if we continue to eliminate, we'll just have, like he said, we'll just have 7 of the same. What's the point of that? It just seems to me we right now we have 4 of the same and 3. So 4 always win over 3. I've been back here for 40 some years. Seems to me that seems to be the policy and what goes on. And it's just things have to change. They're not going to change the way things are going. So we have to figure out a way to make a change. The community needs to speak up. And here I am. So thank you.
Thank you, Mark.
Yep.
Yes. Paula?
My name is Paula Gray and I live at 88 Windjammer. And I concur that I really, really believe that most of the people in here, first of all, we're having a meeting at 8 o'clock on a Monday morning when everybody's at work or at school or taking care of their kids and putting them on the bus. This has been the attitude of this particular board or so, as far as any kind of meetings that would involve us, the residents. That's wrong. They used to be Saturday mornings, 100 and so people would show up. Also, when they're talking about the 3 years, 10 years, about some of the people sitting on this board right now, we all ran at one time and some got elected with a year or 2 here. It needs to be the incentive and the vote of the people you can convince that you're running for. We've had enough of this. There's nothing in these changes that say if I step down, drop down, or drop dead, that the person that they would use to replace me as a board member should be the next person that was running on that ballot that got some support from the community. Not to be insulting, but not just someone that the board picks. That's where we get to the same old again. And it does not reflect the community. Let's go back to reflecting the community. And let's not have any of this done before this election. There's no faith in this board right now, if you haven't noticed. There's not a lot of people that really will even comment anymore, except to each other out here. And it's just because of the innuendo, the actions, the activities, and the loss of some people here. Let's entertain this, let's do some things, but let's have more than one town hall meeting, and let's not have it on 8 o'clock on a Monday morning when we're going to talk about this. The idea is to get people to become involved. I live, as far as your block, I live at 88 Windjammer. The house next to me is for sale. Within 10 houses on our block, we've all moved there within 5 to 6 years. And we're all very active with each other. But we can't seem to get in. People say we don't hear from the board. We don't. And that's one of the things we need to move on with. As far as spouses go, oh my heavens, let's not even go there. Have a safe day, take care, stay well, and hold off on this. This is not necessary right now. It's pushing, it's running downhill ahead of a truck. We have a court order that says it should be in, and we haven't even put that into our referendum yet. It got passed. The court said we're going to do it, and that's not even in yet. Have a safe day, stay well, and get involved.
Thank you, Paula. Frank?
I certainly
So,
will.
as a public comment, let me address a couple of things.
Mm-hmm.
A public comment, yeah. Public.
Name and address.
You're not-
Oh, Frank Daly, 834 Ocean Parkway. Okay, whether we like it or not, as a board, sitting here, and whether it happened or not, we were involved in a court case. That court case showed us that we had serious flaws in our bylaws.
Yeah, the board.
The court issued 45 pages of a judgment where they said we did something and we could have done something different. And Rick and I have talked about this, and I kind of commend him for fighting for what was right. But at all times, every decision was made under the guidance of council based on the rules that existed. And we could go exactly right back to the same spot that we were at in his past election, in this election, if a candidate stepped up, said they would like to run, and they died. Or if a candidate stepped up and said, I'd like to run, and I'm a member of a partnership, or I'm an LLC, and I own property. So what we're trying to correct is known flaws pointed out to us by the court on a lot of these. Point number two that everybody kind of missed. Rush to judgment. Some of these have been in process for 2 years. It costs $28,000 or so to hold a referendum. We won't hold a referendum to change a word on something that happened 2 years ago. But when you have to hold a referendum, you might as well ask all the questions that have come up legally over the time span since the last referendum. And that's the reason for the amount of things in here.
Paula?
If I get thrown out of this room, I will. But I object seriously to a board member coming into this conversation for public comments. And he certainly has the right to a comment, but he is the board member and restricted to the comments by the board. He should not be able to enter into public comments right now. That's my opinion.
So Paula, just to address that, we have entertained that under the last 3 presidents. So that's a precedent that's been set. Joseph?
I would like to, Josette Wheatley,
Name and-
36,
Name and address.
Josette Wheatley, 36 Carriage Lane. I would like to address a comment made by Mr. Thomas. Mr. Thomas, I was in Communications Committee for 3 years prior to being even considered to be asked to step up. Your residential academy, I was the one that pushed that through, that is now currently online for the community to see. So some of us have the best of this community. So for you to say, sir, that we were not involved, I've never seen you on a committee, and I'd love it. I've invited you. Please get involved in your community. Our voices have been there all along, trying to do the best.
Some people,
Thank you.
some people try to be on committees and get turned down.
Okay, let's make this the last comments. We
No,
have a
I've got
lot
one to say.
of left. Please, I'm going to give you the floor, but bear in mind that you've had the floor. We have many people waiting to speak from the team's platform.
Just quickly rebut, after being rebutted. Frank, you know that what you stated was not accurate. Our attorney told us at times to please, that this is not the course of action that we should take. When we went back he told us not to have a reelection. He told us not to do some of the things that we did anyway. I was there. I know Jeremy Tucker did not.
Okay, we are not going to relitigate. Tom, we're not going to relitigate that.
He just told me that our attorney said that this is everything we do to rebut what I said.
Okay.
I understand what you're saying, Colette, but I'm not going to take it. I was there when our attorney stated that this is not the direction we should go. I can't give you legal advice to do that. So that's all I'm saying. And so that's not completely accurate, just so you know.
Mark?
Mark Thomas, 1130 Ocean Parkway. Yes, I have been involved. I've been involved with this case, watching to see what goes on. I've been in court. I was also in court when the judge said, do the right thing. And I was also in court when the judge said the board was being disingenuous, basically saying they're lying. So I was in court for all that. So I'm not quite sure what we're talking about, these 45 pages, because I watched the judge look at you all with 7 different stories, and it was embarrassing. And then all I knew was Jeremy Tucker was getting paid.
Doug?
That's it.
And I had 1,700
Paula,
votes as a board
you don't
member.
have the floor, Paula. Doug?
Doug Park, 16 Sailors Way. Comment. So do I believe that we need to address some of these issues that are associated with bylaws? The answer is yes. What I don't share with my board colleagues is a sense of urgency that it needs to be done right away. This is an important aspect of it. There are issues here that are policy changes that need to be understood by the membership so that when they vote as an educated and informed member of the association, not just checking a box, off of a form. Others are clearly wording changes that are clarifying things. So you'll see in the meeting today, I'm bringing forward several motions that have nothing to do with candidate eligibility, have nothing to do with policy change and have everything to do with some clarifications that were spawned from a work group that was put together last year. It was myself, it was former Director Rogers, who's an attorney, it was Jim Trummel, who's an attorney and our current chair of the Bylaws and Resolutions Committee, and it was Jenny Cropper-Rhodes, who's been involved in many aspects, deeply involved in many aspects of Ocean Pines. Our charter was to try and look at some of the things that we thought were worth bringing to the Bylaws and Resolutions Committee for consideration for bylaws changes. We did that. We finished our work. We disbanded the committee by design and handed those recommendations over to the Bylaws and Resolutions Committee. Some of them got rejected, and some of them, as you'll see today, are being brought forward. So, the process was to bring these things forward based on, a review by the Bylaws and Resolutions Committee and a recommendation. Just bear in mind that I see no risk to the association of not having these things fully vetted before they go to referendum. I believe firmly, and I've shared my opinion with all of you, that we are rushing this process. That doesn't mean we need to introduce more delay. We've got momentum. We're engaged. We have the ear of the community. It's time for us to give it its due process, and that is to make sure that we, A, have the hearing according to the bylaws, and B, I would also offer for consideration that given the amount of change and the idea that we only want to have one referendum, perhaps we do need to have an additional town hall so everybody's engaged. Perhaps the folks that didn't get able to hear the back and forth or make any questions regarding the hearing because they couldn't attend it, would attend a town hall and get a better understanding. What I hope to avoid is the sentiment of the membership by saying they're trying to ram this down our throat and they go no, and don't even give it its due course. So the idea here is my position has always been and remains that we need to give this due process. We need to make sure that we're giving it enough time and enough exposure to the membership before we move forward.
Jim?
My name is Jim Trummel, 1 Annapolis Court, Section 16. I want to make clear that although I've been identified as a chair of and member of the Bylaws and Resolutions Advisory Committee, these are my personal comments only. I do not support the provisions of the motion regarding owner of record. I don't support it because it allows representative capacity for membership on the board of directors, representative by someone who is not a member of the association. I believe it's necessary or proper, rather, to have board members who are responsible for the rights and obligations of the association, the purposes of the association, be members of the association within the Declaration of Restrictions. I see nothing in the motion that calls for a legal requirement or this indicates a that purpose is served by that representation in the board of directors. I believe that the Maryland Code permits reasonable restrictions on what we have, who we have on the board of directors. And I believe it is reasonable to restrict membership on the board of directors to those who are in fact committed legally to the purposes and the rights and obligations of the association. I do not support that motion. Thank you.
Okay, Josh, you have some people with their hands raised.
First up is Monica Rakowski.
Monica, please state your name and address.
Monica Rakowski, 34 Cannon Drive. Can you hear me okay?
Yes.
Okay, thanks. I too do not agree with the proposals surrounding the spouse. The consensus or perception is that some of this is very vindictive and being rushed, and it shouldn't be.
Monica, we lost you there for a second. Could you repeat that?
Oh, yep. Just that things do seem to be rushed. The perception is this is retaliatory in nature. Kind of wondering too about the conviction, a felony conviction. Do we do credit checks for board members? What if somebody has a poor credit score? That would affect insurance and things like that. So how far are we going to go with this? Again, the view is this is coming across retaliatory in nature. So, I just kind of have questions about those other types of things that might affect, credit ratings. So just really asking that you take the time, think this through, you know, and really involve the membership more. It doesn't have a good look right now for anybody. I had emailed every director in the bylaws committee. Frank did reach out to me. Unfortunately, I teach classes during the day. I didn't get to call Frank until yesterday, I think. So the other thing is to be more responsive. What's the process? You know, when you have these special meetings and you try and ask questions, is it just, oh, somebody else will respond? That's not a good look either. So, and Frank, thank you for reaching out to me. But in the email, and Frank replied to everyone, Colette, Frank thought you would, you know, be the person to respond, and that hasn't happened. So other points were made in that email, but you know, by and large, this just it's just not coming across really well for anyone that I've talked to about it. And maybe that's the other thing. How many people have you heard from that are in favor of these changes? You're certainly hearing a lot about who's not in favor of it. Where's the other side of it? I mean, no, that aren't liking it. So anyway, thank you for hearing my time. My email's still out there. Be happy to engage in any conversation. I have recently submitted application for committee assignments to be more involved. So hopefully I can be part of solution and not part of the problem. Thank you.
Thank you, Monica. So let me speak to the process, please, Monica. When we receive emails from the public, it has been our agreement for the various iterations of the board that I've been on, is that all 7 members of the board do not respond to each email. If someone responds and the rest of the board agrees with that response, you will not get a second response. You will get a second response if there's more information to add to what that person said, or if there is disagreement. So I apologize that you did not hear from me. I will read your email again and Frank's reply and ascertain as to whether I have anything to add to the information that you've already received. But thank you for that comment.
Yep, thank you. And I didn't get any response other than to call Frank. So I think, you know, and I did call Frank, but it took me a couple days. And it wasn't until, I don't know, yesterday, Saturday or Sunday. So, but I didn't get any response. So at this point, I would appreciate it if you could at your convenience.
Thank you.
Thank you.
The word you used was vindictive, in case you all didn't know that.
Okay, Josh, do we have another?
Next is Debbie Bloom.
Okay, Debbie, state your name and address.
My name is Debbie Bloom. I'm at 65 Martinique Circle. I agree with Tom Janasek and Doug Parks. We do not need to rush to change right now. With the court case and what that was about, we need to really look at that. We don't need to just take a few months and look at that. We need to really get that wording accurate. I disagree with the spouse issue. I disagree with many of those things that have just popped up in the last few months. I understand we had a committee that has been in place and has been studying it for a year or more. And some of those changes may need to be done now. But to rush on the issues that, and I was in court, I heard the judge. I heard him say, do the right thing. So I was there and I saw how our board members spoke and and I heard what the attorney said, that before we got there, that don't do this, and you all went against his recommendations anyway. So let's not rush. Let's take a minute. Let's pause. We've got time. There are things that need to be done. Do what the committee's been talking about for over a year, but let's not rush on the issues that we had with the court case. It is vindictive, I believe. Thank you.
Okay, any other hands up, Josh, or calls?
No, just one comment in the chat.
Okay, thank you.
Oh, no, Kelly Miller just put his hand up.
Okay, Kelly, please state your name and address. Kelly,
Kelly, you're muted.
repeat it if you didn't hear it. It's Kelly Miller. It's a vindictive action.
And your address, please, Kelly?
103 Pinehurst, and you're all welcome.
Thank you.
to come over. It's a vindictive action by the board involving spouses. Come on. And I'm about, we've got what, 9,000 full-time residents here. Most of us are getting ready to retire or are retired. And I'm putting my house in a trust. So that means I can't run for the board. How ridiculous is that? It's arbitrary that Frank Daly can sit there and write this stuff up to penalize a spouse of somebody who wants to run. How ridiculous is that? And if you're going to do that, you want to go on public record? I got all your credit information. I'll go on public record if you want to push this thing through. Ridiculous.
Okay, thank you for your comment, Kelly. Let me just speak to one of the things that a number of you have referenced, and that is that this is being rushed. And as I said earlier, that we have received recommendations from our council for the last several years that there are bylaws changes that are needed. We do know that the work group and the bylaws committee have worked on many of these changes for a long time. There is not just one lawsuit, but there is another lawsuit from 4 years ago, in which the ownership issue was at issue in the lawsuit. And so now that it has come up again, we do have a long history of thinking about this and considering this as an important topic to consider. And so, I know that it may feel to you like we're rushing to judgment. These changes have been in your hands for 9 or 10 days for you to take a look at. But the board and the bylaws committee, I believe, have really talked about a lot of this stuff for a long time. So with that said, I'm going to close public comments. I think we've heard from everybody, and we will move on to the agenda.
You did have two in the chat real quick.
Oh, I'm sorry. Yes, Josh, please.
Stuart Lackernick and Debbie Bloom just put, they should listen to Jim Trummel. He is a resident expert on our bylaws.
Okay, thank you, Stuart and Debbie. So under new business, the first.
Can I have one moment, please?
Sir, yes.
Okay. I appreciate the public comment section. I would encourage the board to simply acknowledge the public comments when they're given and say thank you. But the rebuttal issue and defense issues coming from the board to the citizenry is not part of public comment. That's part of your actions as a board member, and you show it by your vote. It really is disingenuous in the public comment section to refute and rebut what the public comment person is making. Just leave it to the members, say thank you for your 5 minutes, and move on. And then during your voting process, you can bring up these discussion points within the board member, but not in the public comment. Thank you very much.
Thank you for your perspective on that. Okay, now we'll move into new business. So the first item up is a motion to define eligibility.
Notes with the numbers from the MOS.
Excuse me, you guys are all out of order. We're moving into business now. Thank you. So the first motion to consider is revision of bylaw section 1.12 to define eligible to vote. And this motion is to have council develop the appropriate wording for a referendum to revise bylaw section 1 by adding a new section 1.12 to read as follows. Article 1, section 1.12, eligible to vote, refers to a member who has paid the annual charges and interest levied under section 5.14A and has not had the right to vote suspended under section 5.13E. The effect is to provide a definition of the term eligible to vote. And the background on this is that it is recognized that the term eligible to vote is used in the bylaws without clear definition of its meaning this revision is meant to correct that. This is one of the issues that came up in the recent lawsuit, and it is something that we felt needed to be corrected. Is there a second on this motion?
Second.
Any discussion? Frank?
I'd also like to add, this particular issue has gone back, I believe, 2 to 3 years, Doug, when you were president. And we had somebody that wanted to run for the board, but they were delinquent on their annual assessment. And there was a conflict pointed out within our bylaws.
Yeah.
So this corrects a conflict within our bylaws that has been known and has been worked on for the past 2 to 3 years.
Doug?
Yeah, and following up with that, one of the things that came up during that discussion a couple of years ago was the fact that you're on a payment plan does not allow you to be, in other words, you can't be on a payment plan. The idea was you had to have your assessment paid in full.
Right, exactly.
Thank you.
Any other discussion on this? Okay, all in favor?
Aye.
Aye. Any opposed? Okay, the motion carries. The next motion is Doug Park's motion regarding wording change to section 3.03.
Motion is to have have council develop the appropriate wording for a referendum update to section 303C of the bylaws to read as follows. C, the secretary shall confirm that the member is eligible to vote and valid proxies are delivered to the elections committee no later than 48 hours prior to the beginning of the meeting. The purpose and effect is to make this consistent with the term eligible to vote. And this term is used in a number of sections of the bylaws, and the change will reflect a consistent reference to this term.
Any discussion? Or second,
Second.
Frank? Any discussion on this?
Same thing. It's just reference to the term eligible to vote to keep the wording consistent across different sections of the bylaws.
Thank you, Doug.
Thank you.
All in favor?
Aye.
Aye.
Any opposed? All right, the motion carries. The next motion is also a wording change having to do with the voting to section 3.05. Doug?
Yeah, to have council develop the appropriate wording for a referendum update section 3.05 of the bylaws to read, the second sentence in 3.05 to read, the elections committee shall require identification and verify that the member is, again, eligible to vote. The purpose and effect to make the consistent the term eligible to vote. And as I said with the last motion, it's just this term is referenced in a number of sections and it's consistent with the reference.
Okay, a second?
Second.
Frank, all in favor? Any discussion? All in favor?
Aye.
Any opposed? Okay, the motion carries. The next group have to do with meetings. And the first one is, the topic is adequate meeting notice requirement in.
Madam Chairman, is this in
Yes,
there?
that's an error.
Thank you.
Doug, did you notice there's a typo in
There's a
that?
typo error on that. Yeah, could you?
Yes, sir.
That'll be corrected.
I don't need, well, let me formally recognize the fact that if you change that on the form, I have no problem with that. It's just from 303C
I
to
know.
305.
I know, but I
Thank you,
picked
Doug.
up on it. I wasn't sure.
Thank you, Doug. Okay, so this motion is to have council develop the appropriate wording for a referendum to amend section 4.04B of the bylaws to read as follows. Adequate notice of a meeting shall be deemed to have been given to any member if mailed or sent electronically to the address designated by the members or entities for this purpose. In the case of properties owned by entities or those with multiple owners in common, Ocean Pines will not be responsible for determining who is authorized to provide this information. The purpose and effect is to clarify the required process for providing written notices of the annual or special meeting of the members under bylaws section 4.05 and 4.04, sorry. The background is that section 4.04 of the bylaws require a notice in writing be provided to all members of upcoming special meetings of the membership and specifically the annual membership meeting. This can be challenging and under certain circumstances nearly impossible when the property is owned by an entity with multiple owners in common, for example, LLCs, trusts, and so forth. It became necessary to ensure that the responsibility of providing the designated contact information be placed on the property owners or entities. In the event that more than one set of contact information is provided, or the owners/entities choose to have such related correspondence sent to a separate address, the owners or entities are responsible for designating a single mailing address for these written notices. Additionally, these notices may include election materials and ballots for electing members to the board of directors. Only one notice per property will be provided. Therefore, the written notice will make it clear that the recipient of the notice is responsible for providing this information to all other owners in common of the property for their consideration. Is there a second?
Second.
Frank, any discussion on this? Yes, Jim, I'll suspend Robert's Rules of Orders to allow you to comment.
Unfortunately, this motion does not include the entire proposal from the bylaws committee. And however that may have happened, I'll take responsibility for that. There is a separate subparagraph. This is the existing paragraph. This talks about notice. The missing subparagraph that's proposed deals with the issue of single notice. And that needs to be, I've got it here, I can get it out and indicate to you what I think is missing.
I will entertain a friendly amendment from the floor if you'd like to share that.
Give me a second to get this out, please.
I'll make a motion for the friendly amendment. And can I make also a comment?
Yes.
Since we have here to have council develop the appropriate wording, if Jim just supplies that to us and we forward that to council for the wording, I believe that will cover his concerns.
Would you agree with that,
Yeah.
Jim? Okay.
I can briefly read this to you.
Yes, please.
It would be an addition of paragraph 4. Or section 4.04C to read as follows. A single notice addressed to indicated as to all members in common of the subject property shall be sent to the address designated above. That's what's in the motion now. It is the responsibility of the recipient to forward such notice as necessary to other members who hold property in common with the recipient. Required notices to members shall be sent without regard to eligibility. That's notices of membership. The reason for this additional section is that the charter was amended to include that provision in the amendment and restatement 2013. We've never put anything in the bylaws to state that there will be solely a single notice.
Okay. Thank you. Yeah, thank you for that clarification. And if you could get that wording to Frank, or actually just get it to me, and I'll make sure that it is included in what goes forward to council. Any other discussion on this?
Just point of order.
Yes.
We should amend the motion to the friendly amendment to say that we have agreed to have Jim Trumbull contact Jeremy Tucker directly. So we can pass it, because if not, we can't pass this motion the way it is.
So we could also have the friendly amendment be that we adopt the paragraph that was read by Jim Trumbull.
Either way will work.
Yeah.
We have to indicate that there's going to be a change to the motion as stated.
Yeah. Okay. And as the person who put the motion forward, I will choose to recommend that we adopt the language that Jim has just supplied verbally. We will receive that in writing, and that is what will go forward if the motion carries.
And I'll second that friendly amendment.
Okay.
We got to vote on it, right?
Yep. All in favor of the friendly amendment?
Aye. Aye.
Any opposed? All in favor of the motion as amended?
Aye.
Any opposed? Okay, the motion carries as amended. I probably have that, Jim, to be sure that I have it. Please, you could just cut and paste it in an email for me. Yes.
Summary.
Yes. Okay. Thank you. So I will reinstate Robert's rules. The next motion is a wording change to section 4.03. Doug?
Motion is to have council develop the appropriate wording for a referendum to update the wording in section 4.03 and a revised section 4.03 to read, a special meeting of the members of the association may be called by the president, by a majority of the board of directors, or upon written petition signed by members representing the number of votes required under section 4.07C3. And the purpose and effect is to clarify the required reference to section 4.07 and to change the wording accordingly.
Is there a second?
Second.
Any discussion? Okay, all in favor of this motion, say aye.
Aye.
Any opposed? Okay, the motion carries. Okay, the next couple have to do with general manager responsibilities. The first one has to do with the revision of bylaws, section 8.04 budget, paragraph B. The motion is to have council develop the appropriate wording for a referendum to revise bylaws, section 804, to read as follows. Section B, the general manager or management firm may make transfers of budgeted items within a department and make other transfers of budgeted items as authorized by the guidelines and limits established in the financial policy and financial procedures manuals. And the purpose and effect is simply to clarify language in this section. As currently written, this section allows for the GM to transfer budgeted items within a department, as well as other transfers of budgeted items pursuant to guidelines and limits established by the board of directors. Currently, the permissible actions referred to under this section are codified in financial manuals with which the GM must comply. The language in this section does not refer to those manuals and could lead to the interpretation that the board has established guidelines and limitations. So this simply clarifies that. Is there a second?
Second.
Doug? And any discussion?
Yeah.
Doug?
So right now, the financial policy manual was last updated in 2006. When I was liaison to the Budget and Finance Committee, we had an open discussion about updating that financial policy manual. There was discussion about maybe even bringing in a technical writer or some other resource, but it never really gained a lot of traction. I think at this point, we really do need to push. Once my recommendation to get to the budget, let's push to get someone to look, and I'll certainly volunteer, and we can certainly get a couple of other folks to volunteer to take a first glance at that financial policy manual and suggest some updates that could be brought up for discussion at a later time, and then it's subsequently put in there. Because this whole point here was that, like you said, any board of directors can establish their own, which might be inconsistent from the previous year. It might affect plans from that started in the previous year and are in progress, and then might have to get turned off based on some change in the thought process of the board at that time. So referencing the financial policy manual is the sound way to do it.
Okay, and so can you bring that back to our attention after the February meeting?
I will make a note.
Great, thank you. Any other comments on that? All in favor of this motion, say aye.
Aye.
Any opposed? The motion carries. The next motion has to do with general manager responsibilities. Revision of section 9.02, paragraph C, personnel manuals. This motion reads to have council develop the appropriate wording for a referendum to revise bylaws section 5.14 to read as follows. I'm sorry, 9.02. That was a mistake, typo. So Article 9, Section 9.02C, the general manager shall maintain personnel policy procedures manuals, review annually all benefit programs, wage schedules, training programs, classification schedules, personnel policies, including grievance procedures, and make recommendations to the board of directors. The purpose and effect is to clarify the language in this section. The background, excuse me, is that this section is currently written, refers to personnel policy procedures manuals. Note the capitalization, which could be interpreted to suggest that there is a specific manual so entitled, which is not the case. This revision corrects that potential problem. Is there a second?
Second.
Frank. And any discussion on this?
Just one
Okay.
sort of point of interest, and that is that the way the wording is proposed, it doesn't restrict the general manager from creating a policy or personnel policy and procedures manual.
That's correct.
Okay, just want to say.
Yeah, there is one that currently exists.
Doesn't, so people need to understand, it doesn't restrict that individual from creating one if he or she decides that's what they want to have as part of their operational environment.
Exactly.
Yeah.
And just, for a point of information, there is such a policy and procedure manual in place, which would remain in place unless it were revoked in some way. So any other points of discussion on this? Okay, all in favor of this motion, please say aye.
Aye.
Any opposed? Okay.
Point of information. Saying there's a typo in this one too.
Yes. So it is acknowledged 5.14 is a typo. That will be corrected to 9.02. The next set of motions have to do with petitions and referenda. The first one is a revision of bylaws, section 407A petitions. This motion reads as follows: to have council develop the appropriate wording for a referendum to revise bylaws, section 407A as follows. Petitions must contain a specific question, proposal, or action suitable for an affirmative or negative response. The petition must be in a format prescribed by a resolution adopted by the Board of Directors and signed by members eligible to cast a vote. The petition shall identify the person or persons who will represent the petitioners and contain the lot number or address of the property in the subdivision owned by each member signing the petition. Each member signing the petition must be eligible to vote when the petition is filed. Notarization or self-authentication of the member's signature shall not be required. If more than one person is authorized to cast a vote under section 3.02, only one of those persons may sign the petition. Within 10 calendar days after a petition is filed, the secretary shall certify in writing to the Board of Directors that the petition meets the requirements of this section, or file a public report with the board specifying the basis for rejecting the petition. And this motion, this language also is to clarify the language in this section. As currently written, the section omits a detail that is missing from the petition review responsibilities of the secretary. And that is, the secretary is to file a public report with the board when a petition is rejected. However, the requirement for certifying a valid petition is less clear. The proposed amendment corrects this. Is there a second?
Second.
Frank, and any discussion on this one? I'll suspend Robert's Rules of Orders again for our resident expert,
I
Jim.
apologize, and actually, there's going to be one or two places further on where I'm going to ask the same thing.
Okay.
What has been missed one way or another, if you go down, let's see, it's going to be 3 lines. Starting in the line before that, it's prescribed by a resolution adopted by the Board of Directors and signed by members eligible to cast a vote. That's another one of those voting references that an earlier motion, the definition of eligible to vote is intended to correct. So it was proposed by the committee to end that sentence at directors. So that
Okay.
you remove that and signed by members eligible to vote. Now, if you go further on, a little further, there is in the current provision a duplication where you say each member signing the petition must be eligible to vote. Well, that's fine. That stays in there. But
Yes.
by taking out the eligible to cast a vote, you also go back to a common reference regarding voting, and you remove a duplication within the provision. You don't have to say eligible to vote twice, which is what is done now.
Thank you, Jim. I will reinstate Robert's Rules. Is there a friendly amendment to make that correction?
So moved.
Okay. For a second on the friendly amendment?
Second.
Okay. And all in favor of the friendly amendment as stated?
Aye.
Any
Okay.
opposed? All in favor of the motion as amended, say aye.
Aye.
Any opposed? Okay, the motion carries. Thank you, Jim. The next motion is a motion to clarify the number of valid signatures required on a petition and referendum. Frank?
Okay, the motion is to have legal counsel prepare the specific wording to change section 4.07C of the bylaws. Petitions as follows with the proposed changes as noted in bold. Petitions must contain the number of signatures specified in this section when they are filed with the secretary. To request action by the board of directors not requiring a referendum or to have an issue included in the notice of an annual meeting of the members, a petition requires signatures of members who are eligible to vote, representing at least 100 votes in the association. Point 2, for issues for referendum under section 4.08, removal of a director under section 5.12A, or for amendments to the bylaws under section 11.01, a petition requires signatures of the members who are eligible to vote, representing at least 10% of the votes in the association. 3, to call a special meeting of members under section 4.03, a petition requires signatures of members who are eligible to vote, representing at least 15% of the votes in the association. Purpose and effect, to provide clarity and consistency on a year-to-year and board-to-board basis on the number of signatures required on petitions.
Okay, is there a second? I'll second this
Okay.
discussion.
This is something that goes back again to several years. And the fact of the matter is we have 2 legal opinions currently on the books on the number of signatures required for a petition. One from previous council, Williams, Moore, Shockley, and Harrison, is that number is 10% of the maximum or 845 votes. The second, under Lurch Early, is that in effect, the secretary works with membership and they can reduce the number from 845 based on the people that pay assessments or delinquent. What this does is sets the number at the percentage of the people that members who are eligible to vote and sets it as a firm number, again, from board to board and situation to situation. And again, this is one that's been hanging around. It's not worth having a referendum over, but I would just point out that the variability in this can be wide because when King Richard comes on stream, fully brought into the association, we will have 8,452 people, lots that can vote, plus 60. Okay. However, if somebody would have generated a petition for referendum during the start of the COVID crisis, when the board elected to delay the assessments by 90 days, that number could have dropped into the 600s. And 600 on one and 845 on another, or 900 on a third, just doesn't make any sense. The number should be fixed.
Excuse me.
Doug?
Request to have Robert's rule suspended?
Yes.
I have a question for Jim. Jim, and correct me if I'm wrong, I read your summary from the Bylaws and Resolutions Committee. Was that understand that you said it might be better to reference section 3.01 rather than use the term eligibility to vote, or am I mistaken?
I was going to ask to make that comment. The Bylaws and Resolutions Committee proposal for this is in its operation is the same as what Director Daly described the number of signatures required. However, our proposal referred back to the 301 section as the source of the number of votes. And I think you should consider that. For example, let me see if I can find my way through the bylaws here. 301A, a member shall be entitled to one vote for each numbered residential lot, condominium unit, and so forth. And then refers to as provided in the Declaration of Restrictions or the Charter. That's where you identify how many votes are in the association. That came out of the work group as a desirable thing to reference back to where you can figure out how many votes are actually in the association. I mean, it's a technical point perhaps, but I think it's worth mentioning.
Jim, let me ask a question. You said refer to section
301.
A.
301A. Okay. What I'm going to suggest, since all these are going to go back to council for final, on this note right here, I'll put in refer to section 301A so that when council words it, they can take that. And if you will send that to Colette or myself, we'll make sure that that gets to council, okay?
Okay.
Is that acceptable? That makes sense? Yeah.
Okay, reinstate Robert's rules. So we don't need a friendly amendment for
No.
that? Okay. So, any further discussion on this? Doug?
Just to be consistent, I'm not nitpicking here, but we really do need a friendly amendment because the way the motion is stated right now has been changed. We're actually going to, infer that we are going to get some guidance from council to change the wording. So just.
Okay. So would you make that friendly amendment?
Friendly
Yes,
amendment
please.
to accept the recommendations from Jim Trumbull to reference section 3.01A.
I'll second that.
Okay. All in favor of adopting a friendly amendment?
Aye.
And in favor of the motion as amended?
Aye.
Aye.
So the motion carries.
The friendly amendment was seconded by Frank.
Yes.
Thank you so much.
And you have Linda helping you out here.
Yes, no, I'm aware.
Between the two of you.
Thanks, girlfriend. I'm just, it's a lot of.
Okay. And then the next one is also has to do with referendum, total votes that can be cast, section 408, C and D. Doug?
Motion to have council develop the appropriate wording for a referendum to amend section 408C and add section 408D of the bylaws to read as follows. Section 408C, any proposal presented in a standalone referendum must receive a minimum of total votes cast for or against equal in number to 40% of the total votes that can be cast. And then additional section would be 408D. Any proposal presented in a referendum requires a majority affirmative vote of the total votes cast in order to become effective. A question, proposal, or action may not be, a question, proposal, or action not adopted may not be resubmitted by petition within 1 year of the previous submission. Now it's to clarify the purposes, to clarify the required percentage of votes could be cast to approve referendum. The background. Right now, there's no requirement in section 4.08 for a minimum number of votes. Only a simple majority will pass a measure. Theoretically, this would permit as little as 1% of the eligible voting members to decide a referendum. Since subjects that go to referendum are typically of significant importance, as many association members as possible should be involved in the decisions. So the Bylaws and Resolutions Committee proposes to set a minimum number of votes, but limited to the standalone referendums, and the requirement would be not apply to referendums that are conducted with the annual election of directors. The 40% number is based on research done by the committee and reflected in the proposed changes to 408C and 408D.
Okay, is there a second?
Second.
Frank, and is there any discussion of this? Suspend Robert's rules again for Jim.
I think there was a discussion as the last committee meeting, and I believe it was after you had left, and for whatever reason it never got communicated. In the third line where it says votes cast, comma, for or against, we should say for and against. And at the end of the line where it says total votes that can be cast, it really should say votes eligible to be cast. And that's not a conflict with the eligible to vote. That's the number of votes that can be determined to be cast in the referendum. That doesn't conflict what we've talked about on eligible to vote. That's a different reference.
Okay, any other comments? Thank you, Jim. Reinstate Robert's rules. Doug, will you accept a friendly amendment to make those wording changes?
Yes.
Okay. All in favor of that friendly amendment?
Aye.
Second.
Second.
All in favor?
Aye.
Aye.
And all in favor of the motion as amended?
Aye.
Any
Aye.
opposed? Okay. Now, the next one has to do with petitions, revision of bylaws, section 514L. The motion is to have council develop the appropriate wording for a referendum to revise bylaws, section 5.14L as follows. Duties, the Board of Directors shall consider a petition submitted under section 4.07 and certified as valid by the secretary at a meeting of the board within 60 days of the petition being filed. And the purpose and effect is to clarify language in this section. As currently written, this section omits a detail that is missing from the petition review responsibilities of the secretary. This adds the phrase, "and certified as valid by the secretary." Is there a second?
Second.
Frank, and any discussion on this one? Okay, all in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, the next we have to do with candidate eligibility. The first one is motion to define director qualification in bylaw section 501, 502A. Frank?
Okay. This motion, this call it said, is to define director qualification in bylaw section 5.01 and 5.02A. Motion to have council develop the appropriate wording for a referendum to amend the bylaws to a new section 1.11 of the bylaws to amend sections 5.01 and 5.02A of the bylaws to provide as follows. Section 1.11. Owner of record means the persons listed on the deed recorded in the land records of Worcester County as an owner of the property, in parentheses, grantee for party in the section part within the subdivision to which the votes are attributable. If a trust is listed on the deed recorded in the land records of Worcester County as an owner of the property within the subdivision, then the owner of record shall be the trustees of the trust who is/are listed on the recorded deed to such property. If a corporation, limited liability company, or partnership is listed on the deed recorded in the land records of Worcester County as the owner of the property within the subdivision, the owner of record shall be an officer of the corporation, a living person who is a member of the limited liability company, or a living person who is a partner in the partnership as reflected in the relevant entity's records. Section 5.01, number, term of office, and qualification. The affairs and business of the association shall be managed by a board of 7 directors, each of whom shall be an owner of record of property in the subdivision eligible to vote. The terms of the directors shall be for 3 years and until their respective successors are duly selected. No member of the board of directors may be at the same time an employee of the association. Additional qualifications for candidacy and election to the board of directors shall be governed by section 5.02A of these bylaws. Section 5.02A, all candidates must be an owner of record on the first day of January of the year in which the election is to be held and eligible to vote under section 3.01C. The purpose and effect is to define owner of record.
Is there a second?
I'll second that.
Okay, Josette.
I mean, I think this gets to the core of the issue that we had in litigation where the court said we weren't defining owner of record. And I think it broadens it to include trusts and other forms of ownership that have come prevalent since the last bylaw change. And I'd say also prevalent since the onset of the pandemic. Because right now, I mean, I got a lot of emails saying, hey, you know, the director of record that says you have to be a living person on the deed, as is typically, I think a lot of people have with joint tenants, really eliminates a lot of people who want to put their property in trust and a lot of other ownerships that have come prevalent, again, since the last bylaw change and since the onset of the pandemic, who are members of the community, they're active, they're engaged, and they're perfectly qualified.
A question, and I agree with what you're saying. And one of the things, and this may be maybe some language, if this is the proper form to do that, where you have listed as trustees shall be the trustees, maybe inserting of the language of co-trustees of the trust. Would that be something that?
Rick, it's acceptable to me. Jeremy is on, and we can ask.
I didn't see him in there.
Yeah, I just invited him to join us. Thank you, Jeremy.
So my question, Jeremy, was the trustees of the trust, adding language to that.
That's fine. I mean, the co-trustees are the trustees, so it's sort of the same. It doesn't really make a big difference. We could have trustees, comma, co-trustees, so that they have both. That's fine with me. It doesn't really make a difference from my perspective, from a legal perspective. If the deed, like the deed would say, you know, the co-trustee Jeremy Tucker and Adam Tucker, my brother, and so for me, it doesn't matter. So I'm happy to include that language for clarity purposes, so there's no confusion, depending on how things are titled.
So, Richard, what you're asking is if this could be changed to the trustees or co-trustees
Of the trust, yes.
of the trust. And do you accept that?
Rick wants to make a friendly amendment. Yes.
Friendly amendment.
Okay. And can we vote on that friendly amendment first? Go.
So Jeremy, this is directed towards you. I'm sure that in language in a trust, the term beneficiary is used. So should we make consideration for beneficiary? And then the second part of that question would be, are there any other legal terms that would reference somebody associated with the trust that we should, because of due diligence, include in the language?
Right. So the problem with beneficiaries is, one, you could have many beneficiaries that have nothing to do with Ocean Pines at all, and could be very, all over the country. And the only way we would know who is a beneficiary of a trust is to have to look at the trust agreement, determine whether they're currently a beneficiary of trust or they're a successor beneficiary of a trust, and that would require an additional level of analysis to do that. My preference would be is that it is the trustees who are really the legal owners of the trust are the ones who can make decisions on behalf of the trust and are the owners of the property. The beneficiary trust has an equitable ownership in that, but it is contingent on what happens to the trust. So my preference would be is just to leave it as trustees. And that I think is consistent with owner, the president of the corporation. I mean, it's these sort of direct people who are controlling the various entities / trust.
Understood. And the only reason I ask that is so the public understands that if the term beneficiary is not in there, they know why. Okay. Exactly. And that's the whole point of my question.
Thank you, Doug.
So we'll have an answer. I'm sorry.
Yes, another question.
Follow-up question, and it's spawned from Jim Trummel's comments about his concern for 1.11. It made me think, should we, and I'm only offering this for a discussion point, would be the idea of not having a vested interest in Ocean Pines, i.e. someone from an LLC who is the officer of a corporation. We're basically on this wording is saying, yes, they can be eligible to run for the board. The question would be, if we consider the idea of a vested interest in Ocean Pines, are we doing the best for the association by letting someone who arguably doesn't have the best interest of Ocean Pines? It's an investment property. They don't come here. They just own it. It's a tax write-off, et cetera, et cetera. But should we give them, the opportunity to be on the board of directors? It's a question. My knee-jerk reaction is maybe no, but I certainly want to listen to different perspectives on the concept of them not having a vested interest in Ocean Pines, yet still being able to be eligible to run for the board.
Richard, you had a question?
No, I was just going to bring up the clarification piece on the
friendly amendment.
On the friendly amendment of adding the co-trustee of the trust. That was all. I understood the position on the beneficiary piece, but I just wanted to see if that was the co-trustee of the trust was going to be added. if that's.
Okay,
Yes,
that's
that was it.
what we
You make a
have right
friendly
now
amendment.
pending us.
Friendly amendment on adding co-trustee of the trust.
Yeah,
Okay,
I'll second.
okay. And all in favor of adding that change to this motion? Okay.
Aye.
Aye.
Now we have the issue of the corporations and LLCs. Any other comments on that?
Yeah, I mean, you know, here's, I think, the unfortunate situation. I mean, you know, and when I say unfortunate, Doug, there's two sides to the equation, right?
Sure.
You've heard, we're exclusionary, okay? Well, if you want to be inclusionary and you say, and you recognize all the legal type of situations that can now occur where somebody can be living in Ocean Pines, residing in Ocean Pines, and under one of these separate things. And when you try to go inside that and say, but because you're an LLC, supposing you're an LLC and you work in Washington DC and you don't come here very often, except 2 weeks in the summer, but they're actively engaged in the community by following the media, by following the board. How do you, it's too granular, you know what I
Yeah,
mean?
point taken. And
Yeah.
that's why I wanted to get it out into the public to discuss it, so that if we move forward with inclusion of an officer of an LLC as being eligible to run for the board, I want the public to know that we brought it up, we discussed it, and based on what you just said, that should be a consideration.
Yeah, I mean, and I think, and I just defer in the discussion, I think, Rick, this addresses one of the core issues that you had with us, okay? And I'm happy with it.
Yeah, the question that I have is, should any officer of the LLC be entitled to run? You know, theoretically, an LLC, you know, could be owned by multiple individuals who operate within a hierarchy in their ownership of that LLC. And Jeremy referenced the president of the LLC, you know, possibly being an appropriate consideration. You know, what about the treasurer? What about the secretary? You know, the other officers who may have less direct interest, either financial or, you know, otherwise in the property. You know, that's my concern with this. I would consider allowing the president of a corporation, maybe vice president of an LLC, but I think you get into the other officer positions, those could be, you know, not really owners of the LLC. I mean, am I correct in saying that, Jeremy? You can be an officer in an LLC without really owning the LLC.
So let me add, I think the way the amendment is drafted is that it is the officer of a corporation and a member of an LLC, as opposed to the officer of an LLC. So the member of the LLC are just those who have sort of control, we could limit that and make it the managing member of the LLC, which would be the one person in charge of the LLC. And we certainly could do that. The reason why, you know, the way one of the original drafts of these amendments really restricted it, just to get to Doug's point real quickly, was looking at a natural person and limiting to and only having a natural person owner. And I think there was reluctance of that, what that limitation would mean. So we expanded it out, or the board wanted to expand it out to include the officer of a corporation, which matches the length of the rise to vote on behalf of the corporation, which is where that language came from. So that's how we arrived at that language. And then it would be a member of an LLC. We certainly could restrict it down more to be the president of the corporation and the managing member of an LLC. But just as an example of, you know, let's say an LLC is formed to own property and the husband and wife are the members of the LLC. You know, I don't know that it makes a difference between which one of them wants to run for the board. They both have interest in the property, and if they want to serve on the board, if this amendment gets passed, either one of them should be have the opportunity to run for the board. And sort of how I view it, to give them both the opportunity. But we certainly can restrict it down more if the board is interested in doing that, and certainly if the membership feels that that would be more palatable to them.
Yeah, and, I just know how my corporation worked. And in my corporation, it was owned by myself and my husband. We occupied all the officer roles, but theoretically, we could have had another individual employee occupy an officer role. And, my thought is if we use co-members, managers of the LLC, we may do president, vice president of an LLC or a PC that may own property. So that's my thought. So Jeremy, would you agree with that the managers of an LLC are kind of akin to the president or vice president of a corporation?
So we can certainly have managing member of an LLC. A lot of LLCs will be sole member LLCs.
Okay.
And so, but then that sole member would be the managing member.
Okay. And do LLCs typically have co-ownership? Like say if I had chosen to do an LLC instead of a PC for my business, my husband and I may have been co-managers, equal authority and equal ownership.
It can happen that way if, depending on how that you set up the operating agreement for the LLC. Okay. So you could do it that way.
Okay.
So an LLC is comprised of members. So the members are the decision makers based on the operating agreement of the LLC. And so generally speaking, there'll be a managing member, the one who's really in charge, just like a president in analogous terms of corporation. But the way most properties are held, these type of properties are held by small LLCs set up by individuals that have 1, 2, or 3 members for LLC, and they're generally single purpose LLCs that are set up for liability purposes to own the property. And so for me, it is not unusual. One of the other versions that we had, just to give you, I don't want to make things more complicated, one of the original versions we talked about is having the LLC designate a representative who is authorized to act on its behalf. But then that requires us to have designation forms, monitor those designation forms, make sure they're updated. And that's where it sort of became problematic from an administrative standpoint. And we all sort of settled on the member, but we could certainly make it a managing member of the LLC.
Yeah.
So, after obviously discussion and further thought, it's like, maybe we don't need, well, my position is we don't really need to get down into the weeds, into an LLC. There's no reason for us to sit there and say, well, are you a managing director? Are you a co-owner? And so on and so forth. We don't need to incur that administrative overhead because number one, I think it sets up the potential for a challenge. All right. So you've denied me eligibility for something. And guess what? We've got another lawsuit coming down the road. At the end of the day, it's the membership that's going to pick that individual, not the board. So I don't have the same trepidations to say, well, you know what, the way it's worded right now, a member of the LLC, okay, because at the end of the day, the community is going to pick that individual. And I think that, it's far less risk to leave it the way it is than to sit there and try to challenge the definition of managing owner, co-trust, whatever, for an LLC. Just stay out of that whole business. And, and let the community decide. I would say, let's not change it. Let's leave it the way it is and move forward, other than the change about the co-trustee.
Yeah, by the way, as a point of discussion, I'd leave it there too. And I think that, look, there's a point that I think frequently gets lost in this whole discussion. We are not changing anything. We are asking 8,000 people if they think this change is desirable. And the majority rules, and I think it addresses an issue, and I think it's as clear as we can make it, because if we go to try to every permutation that's possible legally, it's just, we'd have a 1,200-page document.
Endless.
Okay, so I have one other friendly amendment, and that is on line 2 of the second paragraph, 7 directors, each of who. The objective case is required there, so that would be whom. So could we make that editorial correction? Are you okay with that, Frank?
Yeah, I think we can just change that.
That to whom.
Yeah. That doesn't change the intent.
Exactly. Okay. So, so no further discussion on this? Okay, all in favor of the motion as amended per the co-trustee and the grammatical correction?
Approve the friendly amendment first.
We did.
We did?
We
Yeah.
did, yeah. Rick was first, Frank second.
Okay.
Thank you, sir.
Okay, so all in favor of the motion as amended, say aye.
Aye.
Any opposed? Okay, the motion carries.
Okay.
Okay, the next one, Frank. What's your,
Take a quick.
yeah,
bio
so
break.
we have a 5-minute recess?
Yeah.
or-
Sounds great.
Okay.
Lovely amendment. Thank you.
Okay, Josh, we're back in session. Thank you. So Frank,
This is yours, right? The next
oh,
one,
it is
5
fine,
minutes.
sorry. So this is a revision of bylaw section 502A to add paragraph 3, incumbent and familial relationship. This motion is to have council develop the appropriate wording for a referendum to revise bylaw section 502A3 as follows. No member shall be a candidate for election as a director of the association if he or she is an incumbent director completing a second consecutive full term of office, has a familial relationship through marriage, parentage, or is a sibling of any other member currently serving on the board. The purpose and effect is to restrict members who have a familial relationship from serving on the board at the same time. This adds a requirement to one that was not there before. So the incumbent director language was there, the familial relationship language was added, and this came out of the discussions with the bylaws committee. Is there a second?
Second.
Frank, and any discussion of this one? Doug?
I get the concept. I'm just concerned that the term familial relationship is a bit too vague. What happens if through a remarriage, you end up becoming, have some kind of familial relationship? I guess, again, I understand it, but, again, looking at my notes, suppose the director gains a familiar relationship during his or her tenure on the board after they remarried. Are they automatically kicked off the board? In other words, that's a possibility, John Doe marries Sally Smith, who, or maybe they're on the board and they get married. I mean,
Well, it could be the same situation.
Yeah, and so.
When I had to resign an officer position because I became a candidate.
Well, no, that's different.
It's not being kicked off the board, but you make these decisions being aware of that.
Well, okay,
Yeah.
so in that case, if we adopted this particular bylaw, then in the situation that I described, how would it be handled? Would said individual director be asked to leave the board? Let's say they're just a regular director, they're not holding a officer position. What happens then?
We just can't get married.
Sorry, honey.
Yeah, we didn't get that memo, Amy.
I read the and then I get her answer.
I mean, granted, it's funny, but the idea is, we're sitting here making sure that these kinds of things are addressing all the conditions that we could think of, okay?
Yeah, but I think it's also, that may be what's
Sure.
required.
Husband and wife, yes, it's a no-brainer, okay? I mean, no, it's the standard business practice, and that's okay, I can get behind that one. It's just that when you get some of these other unique conditions, either A, we get more specific with this language, or B, we have to at least mention that other situations may require decision-making with regard to either eligibility or service. I'm not trying to make it overly complicated. I'm just saying, I don't want to have it come back and somebody challenges it because they create this situation and we go, oh gee, we forgot about that. And then we look silly. Or we make it, so complicated that, again, the public will go, nope, won't even give it any consideration. So, the idea here is to try and make it as clear as possible, so.
Jeremy, do you have any advice on this?
Not that don't get married.
Yeah, I mean, I think my perspective, I hear you, Doug, and there's always going to be hypotheticals that could come up, but I think if the purpose of this amendment, and it is it's consistent with around the country and there's case law to support this amendment, is that spouses, or however we've defined the spouses and in the document, should not serve on the board at the same time. And so if two people are decide that they want to get married while they're on the board, then they're going to have to make a decision about who's going to resign.
Okay.
Under this provision, and I think we want that to happen. If the membership chooses to have this restriction, that's what they also want. They want to avoid that potential conflict between dual loyalty between your spouse or the corporation, and I think the appearance of that conflict. That's why these provisions are all.
Yeah, and again, as I did with other ones, the reason I brought it up so that the public is aware of the fact that this could happen. We considered it. I am behind it. Okay, I'm fine with it. I'm just saying we have to make sure that we do for those extenuating circumstances, or maybe it might be statistically irrelevant, but we still have to account for it.
Yeah. And Jeremy, one more question about the wording. Do you believe that this covers a non-marital partner, life partner situation, or do we need to have something else in there? Because I think the idea is the loyalty, the dual relationship issue.
I mean, I think it covers as much as, let me just pull up the exact language so I can look at it in front of me.
Guys, if you need water, there's some in the fridge.
Yeah, vodka's not served till after 9. Kidding.
I mean, it covers what we wanted to cover, which is sort of this when it's a spouse. It doesn't necessarily cover if it is for lack of a better way, my girlfriend or boyfriend that I'm living with, right? It doesn't cover that. It really is intended to cover, what would be a legally recognized relationship for decision-making purposes, tax purposes, those type of things is what this amendment does. I think when we start getting down to cohabitating, I mean, I guess we could do that, but then we're starting to define what cohabitation means. If I have a house and my girlfriend or boyfriend has a house and we live together 3 days a week because we have children. We have children with previous, I mean, it gets really, we start having to start evaluating all of that. Right. And that just gets things more complicated. So does it cover every possible scenario? No. I think the intent of the amendment was sort of these legally recognized relationships that have legal consequence. And I think that's where the drafter originally came up with it. And that's sort of where I land too, because I think otherwise we're really in the weeds now trying to define what type of relationship somebody has. I mean, we could go forward if they both share a legal residence, then we could have that. So we could drill down if we wanted to and come up with language. But again, the intent here was to keep it really at that sort of legally recognized relationship level.
Amy? I had a question. Should we include language to this effect for appointees as well? I didn't see that appointees shouldn't have
This is true.
So that you're not appointing the wife of a present board member or vice versa. I think there's.
Yeah, I did ask Jeremy that question. He might want to respond to it.
Jeremy, did you hear my question?
I did. So just like the sort of way the bylaws are set up now, none of the amendments specifically address the appointee qualifications, other than what would happen if an appointee was appointed and we found out about, for example, the criminal behavior, the criminal history, or they become delinquent. We could certainly add an amendment that would apply for not only is this deal with election qualifications, but also appointment qualifications. So for all of these amendments to 5.02A dealing with qualification, we can add in there, this shall be for election candidacy for election or appointment. And so we can add both of those in there. My guess is why it was not originally included is that the board, when you're dealing with the appointment of somebody afterwards, it is the board that is making that decision of who they wish to have on the board. And so the board would be hopefully evaluating these various criteria, this and whatever other criteria they wish to evaluate, and making the decision of who to appoint. So we certainly can add that into 5.02A and for appointment purposes, but that's, I think, the reason why it was not there.
So language that all of the 5.02A criteria would have to be met for an appointee to be eligible to be appointed. That's what we're saying. And that would require a friendly amendment someplace other than this one. Right.
I would not certainly object to that friendly amendment, but I would ask this question. There's other things in 5.02 when we talk about eligibility, like, the payment of the assessment, owner of record on January 1st of the year. So would that in fact, let's just say, take the hypothetical. Somebody says, well, why a 3-year residency? So let's just say for the heck of it that we throw that out. They're a 3-year ownership or on a committee. And somebody moves in December 29th and close on their house. And on January 2nd, we want to appoint them to the board. Okay. They would have to meet the owner of record and we would get into more messy situations. Certainly don't object to the appointees meeting the same qualification. I think what Jeremy's saying is that the expectation has been in the past that the board puts at least the most stringent qualifications of the bylaws onto appointees, if not more stringent.
Doug?
Yeah,
That's correct. I mean, that's my thinking.
Yeah, and I agree in concept. I'm just looking at this going, maybe, this section is candidates for election, okay? And really has nothing to do with appointees. So I guess in the instance of trying to have a, appropriate or proper organization, should another section be added? That certainly, and you talk about renumbering a whole bunch of things, so on and so forth. But the idea here is I think we do need to capture the notion that, an appointee is held to the same standards, as someone who's eligible to be, on the docket or
Yeah, and
elected. So
504A and B maybe would be the place to put that. And that would require not a friendly amendment, but a whole new motion.
I think when we come back, how about this? When you figure out all the 50.2A amendments that you're going to approve, the qualifications, then we can look to evaluating to add it to the appointment section of the bylaws. And maybe the language could be very simple. All appointees shall meet the same qualifications as set forth in 5.02A and if we want to exempt out something such as must be an owner of record as of X date, we could do that, but we can all add it there. So once we know what we're looking at, which are going to be approved, then I suggest that we come back to this, put a pin in it and come back to it at that point in time, once we know which amendments you're going to put forth to the membership.
I like that idea.
Agreed?
Great.
Okay, so we are not going to change, where are we with this one?
So just can I ask a question?
Sure.
Just so as a point of clarification, Jeremy, here's kind of like, we're kind of locked into some things process-wise under the bylaws. And one of the things is, as I understand it, the minute that we voted on the First Amendment here, first bylaw change that says to have you review it, it has to be in a yes/no format. Now we're on a clock and we have to have a hearing in 15 days. Okay. So what we're actually saying is that at some point in time before we adjourn today, we make another motion that doesn't exist right now to have you, based on what we have done, change that. I think it's section 5.04 for appointees to be consistent with any change that we made for candidates. Is that correct?
Right, it would be, depending on what gets out of here, what I would think it would be something like, I'm just looking at the language. So we would add a D to 5.04 and say, you know, the board may, the candidate, the person filling the, appointed by the board to fill the vacancy must meet the, also must meet the qualifications set forth in 5.02A.
Yeah.
Yeah.
Something
Right.
pretty
That's
straight.
right.
Or we could add a sentence to 5.02A that says any successor
Yeah.
should, shall meet all the qualifications set forth in 504A.
But I would argue that, remember, the section 502 is candidates eligibility.
Yeah.
And section 504 is vacancies. So
Yes.
you're right, it should sit
Yeah.
in vacancies.
Yeah,
rather than
but put it
502.
at 405, 504A. We don't need to add a D to it because we're already stipulating,
That's, okay.
either way. I mean, it's
That's
wordsmithing.
wordsmith, yeah.
Yeah.
So just to clarify again,
That's fine.
so under Robert's rules, we can make a motion at the end of this to modify 5.04, have you write that amendment, correct?
Right, let me just ask a question. Did you adopt the agenda at the beginning of the meeting?
Yes.
Yes.
Okay, then you'll need a 2/3 vote to add something to the agenda. First, you'll need to have a motion to amend the agenda approved by a 2/3 vote. And then to add this motion to the agenda. And
Okay,
then
so-
we can move forward.
Makes sense.
So we have to vote on this first, correct?
Yes.
Yeah.
Okay,
Without any changes.
so let's vote on this.
Okay, so are we satisfied with the familial relationship
Yes.
Yes.
issue? So siblings, parentage, all of that?
Yes.
Okay.
Yes, ma'am.
So no further discussion on this. Suspend Robert's rules for Jim to comment.
There's been some discussion about rationalizing, if I can, various provisions. Two comments here. This motion we're talking about refers to the not being an incumbent after 2 terms being a candidate. That provision appears in 3 motions, 2 to follow shortly thereafter. You need to make sure when you approve these motions, somebody goes through and picks out where there is repetition, if nothing else. And in this one in particular, we've been talking about familial relationships. If you go further on here in a couple of more motions, you get into another detailed discussion of who's eligible in a somewhat familial relationship context. I'm just asking that you be careful with somebody who rationalizes where there may be conflicts in which are motions that you're approving. There are in fact 3 motions now, including the one in front of you, in which that 2-term incumbent ineligibility is discussed, but not one is, that's all it says. And the other is incorporated in another familial relationship type of motion. Again, I just.
And so your point being that if we're going to add to that.
Well, we just need to be careful what you're passing and what the package you've got left over, that you've got stuff in there that not necessarily conflicts, but you're duplicating or conflicting somewhat.
Okay.
That's all my only point.
Yeah, I guess I wouldn't be concerned as much about duplication as I would be about conflicts.
I'll leave my comment as is.
Yeah.
Somebody put these motions together in an exact form for the bylaws and then look and see what you got.
Exactly.
That's
Yeah.
all I'm saying.
Great. Thank you, Jim. Okay, Robert's rules back in reinstated. So no further discussion. All in favor of this motion, say aye.
Aye.
Aye. Any opposed? Okay, this motion carries. The next one is Frank's.
Okay. Motion to define candidate eligibility in bylaw section 5.02A, annual charge dates. To have council develop the appropriate wording for a referendum to amend section 5.02A of the bylaws to add a new subsection to provide the following. Section 5.02A, candidates for election. The eligibility requirements for election to the board of directors as provided in this section. In addition to the requirements contained in section 3.01C of these bylaws, any candidate for the board of directors shall have paid the annual charge for that year, including any assessed interest, by May 15th of the election, year of the election, and to conduct said referendum. Purpose and effect is to provide clarity and preciseness to the bylaws.
Is there a second?
Second.
Okay, Richard. Discussion? Doug?
I understand the concept, but, what happens if they pay their, their assessment and the late fee they incurred by June 1st?
Then they're not eligible.
Okay, just,
Yeah.
yeah,
This is what came up in the previous lawsuit.
yeah.
The issue of the timing of the payment, and it was not explicit in the bylaws, but it was convention.
Right.
This is how it was
The
interpreted.
reason I say that is because the assessment is due on May 1st, and we need to go back and make sure that May 15th is representative. Any requirements that say it must be paid by this date, or you will start incurring late fees. All right, so just make sure the cross-reference is there is all I'm putting. So Frank, I'm assuming you did your homework and that May 15th does indeed, represent where someone would be charging or someone would start to incur late fees based on the fact that their assessment was due on May 1st.
I haven't done the homework on the assessment of late fees, but what I believe the homework has been done and I think has been made clear to us. There's one thing that we can do. We can have a separate set of qualifications for running for the board. We determine the qualifications for the board, and I believe this fits into that.
Okay, all right.
Okay.
Just
And
pointing
it
it out.
applies only to candidates. Is that correct, Jeremy?
This would only apply to candidates. Yes, they would have, I think the intent when you, I shouldn't
I'm okay
speak for
with
you,
it.
but I think the intent is that, so.
Yeah.
And is your concern that they would be considered delinquent up until the 15th, but on the 15th, they're no longer delinquent? So they would have paid any assessed fees based on that delinquent?
Well, on May 2nd, they're delinquent.
Exactly.
So one could argue that, well, that individual is delinquent on their payments. Why are we letting them run for the board?
Well, because they've satified that
Okay.
delinquency by May 15th.
Again, you and I have been on the board long enough. You
Yeah.
have to anticipate those kinds of questions. You got to be able to explain them. So
Right.
the idea is we're putting this in writing and say, yes, you know what? The situation can exist where said individual on May 3rd is delinquent. However, that does not disqualify he or she from running for the board.
Right.
Okay, on May 15th it will, but not until then. So just be prepared to answer that question.
Well, the candidate verification occurs by the 15th. And so that's the point at which it becomes relevant.
Yeah, like I said, I'm okay with this. I
Okay.
want to make sure we've covered all our bases.
Okay, so any further discussion on this? Okay, all in favor of this motion, say aye.
Aye.
Aye. Any opposed? Motion carries.
Okay. Okay.
Frank?
Okay, motion to define candidate eligibility in bylaw section 5.02A, duration of ownership. To have council develop the appropriate wording for referendum to amend section 5.02A, the bylaws as follows. Section 5.02A, candidates for election. The eligibility requirements for election to the board of directors as provided in this section. Eligibility. To qualify to be a candidate and to be elected to the board of directors, candidates must be one of the owners of records of real property in the subdivision for a minimum of 3 years prior to the first day of January of the year in which the election is held, to be eligible to vote under section 3.01C, unless for the purposes of duration of ownership, they have served on a committee or an advisory body established by the board of directors for a period of no less than 12 months prior to May 1st of the year in which the election is to be held, and to conduct such referendum. And this is to provide clarity and preciseness to our bylaws.
Okay, is there a second? I'll second this for the purpose of discussion.
Okay. It's okay, so let me first explain a whole bunch of things. I guess maybe we should start at the beginning. There are a number of these proposed bylaw changes that came from me. Some of them came from the committee, suggestions from committees, and some of them came from suggestions from people in the public. This actually came at the end of a candidate forum this past election from a member of the public who said, I think that it would be a real good idea that qualifications to run for the board included that you had to be a member of the committee. So I thought about it for a while, and I would say this, I think every one of us, perhaps Rick's the exception, have served on a committee or have.
I'm the exception as well.
Okay, have served on a committee. And it's a good way to learn the inner workings of the association. However, that is extremely restrictive because I think if you went to the head count right now and you looked, there are probably 50 plus or minus 5 people on committees. And your candidate pool then all of a sudden drops from 8,452 if everybody pays their election to maybe 52. And that's too doggone exclusionary. So, but the other issue that came up, and this is where I use just my own personal experience from it. And I have to tell you, to be honest, the reason the person made that suggestion wasn't you, Rick. Okay, when I say this, one candidate almost did not make it. One candidate almost did not make it to the candidate forum because they did not know where the golf club was. Okay, and it just strikes me that if you're going to be voting on renovating the administration building, renovating something at the golf course, redoing the Northgate Bridge, that you should at least know where they're at. Okay, and have that kind of knowledge. And there's nothing in there right now that would restrict. 3 years came about because, quite frankly, when I moved in here, I mean, I just started doing, I think what a lot of people do. You read the papers, you start picking up stuff. And it really took a year and a half to decide to get on a committee. And it really took 3 years to fully understand some of the stuff that's going on within the community to the point where I really think that you can function effectively on the board out of fairness to the people that elect you. Now, I recognize there's a counterpart to that argument. And here's the counterpart. The chairman of AT&T can decide to buy on Turns Landing and say, I'm interested in this community and can run for the board next year. And I bet you he would be as good a board member, if not a hell of a lot better than any of us. Okay? And I'm going to ask you, what do you think the chances of that happening are? That's my discussion.
Doug?
Good point.
So I'm totally against this because for that very same reason, Frank. First of all, I think what we're talking about is the difference between eligibility and qualifications. All right, those are two separate things. Eligibility is one thing. We're the crux of the discussions that have been going on have centered around eligibility. Okay, we we certainly have to have the input from the membership, but we're more inclined to define items for eligibility that can be considered by the membership to be put in the laws. What we can't define as a board is what somebody perceives as a qualification for his or her candidate of choice. All right, we can't do that. And if you think we are, you're way out of line. Okay, the idea of somebody saying, I know 3 years is an arbitrary number, but my argument, reduction absurdum, says, by the way, 2 years, 364 days, you're adult, you're uninformed, and really couldn't spell Ocean Pines. It was presented to you in a dictionary. But yet, that very next day, you're empowered, you're more relevant, you're more engaged, you're more appropriate to be involved. I just don't buy that, okay? Some people, like your example with the CEO from AT&T, may need 2 weeks, to come up to that, okay? And while I respect your thought on this, I think the generalization that it takes everybody 3 years in order to reach a certain point where they can be beneficial and run for the board is erroneous. That is a generalization, and I cannot apply that kind of logic because I don't believe it exists. The idea here is that anybody that shows an interest in running for the board with regard to eligibility, okay, i.e. paying your assessment, those kinds of things, should be something. But qualifications, No, that's for the public to decide. The second part of it would be, okay, we can circumvent that by 1 year, on the committee. Well, that kind of surmises that there's always openings on committees. Now, granted, there are, but there might be a situation where there's not an opening on a committee. You have a perfectly qualified candidate who's also eligible, but can't run because they haven't been here 3 years and there's no room on a committee. And that to me is exclusionary. That's not including, we were remiss in an opportunity to get some intellectual property and some intellectual capital invested in our organization, by being, restricted like that. I just don't think there's any merit to something like that. Let the public decide the qualifications, okay? And, we can determine with the public's help, the eligibility. So I'm absolutely against this. I think it's absolutely wrong. It's far too restrictive, and I will not be voting to support it.
Amy? I understand your intent. I think your intent is clear. It's to have a more experienced candidate pool. But that's not an eligibility question. That's a qualification question. I get it. Ocean Pines is a big place. If you're not here, you probably haven't even experienced snow removal like we just did. So I understand the intent, but I believe that with the revamping of the search committee, it's going to help us get more quality candidates. And as a voter, I'm looking for the candidate that has the most experience, but that's my choice. So I feel like we need to leave it up to the voters to decide.
By the way, I respect both of your positions, and as such, I'll withdraw the amendment, the motion.
Okay.
Fair enough.
Okay, but I just want to go on record as agreeing with Doug and Amy. So I seconded it for discussion, not because I agree with it. So
I
the next-
actually agreed with it as well. I was torn with the 3 year prior. It is, like the qualified candidate. I do believe you should know your community before you jump into anything. That's my personal thought. So I understand where Frank was coming from with that.
But how long it takes is arbitrary.
It's arbitrary.
And I would agree with that. That's why I withdrew it.
Okay,
you,
the
sir.
next one, Frank.
Okay, motion to define candidate eligibility in section 5.02 family relationships. To have council develop the appropriate.
Okay, this is repetitive of the other family relationships one, isn't it? I'll read it and we'll discuss. Go
I
ahead.
thought it was the same,
Yeah.
to your point.
Okay. Yeah.
This just defines it differently. Spouse through marriage, cohabitation, common law, civil union, parent or sibling.
Right.
So go ahead and read it. We can decide if,
Okay.
what we.
To have council develop the appropriate wording for referendum to amend section 5.02A of the bylaws to add new subsection to read as follows. The candidate may not be an incumbent director completing a second consecutive elected full term of office, nor may the candidate's spouse through marriage, cohabitation agreement, common law marriage, or civil union, parent or sibling, be an incumbent director. And to add, to conduct such referendum. It's to provide clarity and preciseness to our bylaws.
Second,
I think we covered it.
I think we covered.
I think we covered
Yeah,
it.
you want to withdraw?
Yeah.
Okay, the next one, Frank.
Okay. Motion to find candidate eligibility bylaws in section 5.02A. To have council develop the appropriate wording for referendum to amend section 5.02A, the bylaws to add a new subsection to read as follows. The candidate may not have been convicted of a felony within 10 years of May 1st, the year in which the election is held, and to conduct such referendum.
Second. I'll second for discussion.
Okay. Now, this is the candidate for the board of directors. And it comes to there's a couple of issues here, okay? So let's put some things on the table. First, homeowners boards in the United States are not trusted and not well-liked, and that certainly applies to Ocean Pines, okay? I mean, you know, we catch a lot of flack from the people for a lot of different reasons. When you have a felon sitting here on this board, that is not going to do anything to build that community trust, okay? And I want to address all the issues in one blanket statement with felons, okay, that have felony in them. Some felonies like this, when it applies to the candidate themselves, is very broad, okay? Because there are a lot of crimes that people could sit here and create a bunch of havoc. For example, certainly financial crimes, okay? You don't want a felon anywhere near the financial and management decision-making processes of any corporation or any board. But, you know, people that have said, well, this is, I don't like this felony thing, you know, I don't think that somebody's going to put on their balaclava and attack the finance office with armed weapons. That's true, okay? So you could say vehicular homicide, you could say felony DWI, there's a lot of things. But then you get into some specific issues that I've talked about with counsel, with Jeremy, such as sex offenders. How would you feel sitting on the board here finding that you have a sex offender? And how would the community feel? So I think this all comes under the thing of holding the board of directors and the person sitting here to a higher standard and to eliminate any possibility or perception that that standard is not being met. That's why we talk about board members on this motion.
Baby. I did a lot of research. It's common to eliminate convicted felons from HOAs. I found plenty of examples of that. Most of them, the examples did not limit it to a scope of felonies. They just said, if you're a felon, you can't be on the board. I think California was the only exception. California allows everything. I mean, you can be 15 years old and serve at the park. I mean, California is a little nuts. My issue with this was the 10 years. And that's because reading this, someone could have been convicted 10 years ago, and then they get out of jail, and at 10 years and 1 day, they're eligible to be on the board and they're still on probation and everything. So I did some research, and some states have tried to counter that. And the way they do that is, like Florida says, it eliminates felons for 5 years after all the terms are met. So after they've paid their restitution, after they've done their probation. So I think that might be something that we need to look at. Texas banned felons, but they didn't give a time limit. They said in Texas, when your voting rights are restored. So I have a problem with the 10 years because it leaves us open to someone still being on probation and still owing money in restitution. So I think we need to, if we're going to go with this, I think we need to somehow make it a time limit after all the terms are met, including their probation.
Yeah, I would certainly accept the friendly amendment. And I don't want to jump ahead to a different discussion, but I want to, if you give me a chance to look at something here, and I want to explain the 10 years to you, okay? There is a study put out, it's called Recidivism Amongst Federal Offenders, a Comprehensive Overview. It's put up by the United States Department of Justice, okay? And the reason I chose the United States Department of Justice is if you go state by state, like you say, if you look at California versus Georgia, you're going to see a big difference on how felons are treated over a period of time. The federal criminal system has roughly, within, not precise numbers, roughly 1 million people in it, okay? And they release people and probation people every year, and they keep track of it, okay? I'll just read, again, I don't want to jump ahead to a different discussion, but I want to give you this fact. that occurs in the discussion. Federal offenders' criminal history was closely correlated with recidivism rates. Now, recidivism is that felon committing another crime to be incarcerated with or put on probation for, okay? Rearrest range from 30.2% for offenders with 0 total criminal history points to 80.1% of offenders in the highest criminal history category. Okay, recidivism rates for those on probation and parole is also high. 43% of the felony probationers and 62% of parolees will be rearrested within 3 years after beginning community supervision. Now, when you go into that same report, they have a chart that looks at recidivism rate over time, okay? And that recidivism rate over time drops from these numbers down to 1.8% after 10 years. And that's why I chose the 10 years, because I'm willing to say after 10 years, based on the federal prison system and the Department of Justice, that the chance is very small. In between there, I mean, you take your risk, but that's the purpose for 10 years. But I'm certainly willing to say, hey, look, you know, when something happens, but again, it's how far into the weeds do you get?
Yeah.
Okay. And again, it's something that I would not personally feel comfortable voting on. I would feel comfortable voting on this. I mean, no, I'm not going to kid you. I don't want criminals anywhere near our financial and management decision-making process. But I feel a heck of a lot more comfortable putting this in front of 8,000 people and saying, what do you think about this idea? Okay. And if they think the 10 years is too long, I mean, I can explain the 10 years. But if somebody wanted to go with 5.
Now, let me ask you a question about that 10 years. Is that 10 years from having satisfied their sentence? That's what it sounded like that data meant. Not 10 years from the conviction.
Right.
Or even 10 years from the commission.
I think it's 10 years from their original sentencing.
It can take years to get a conviction.
Yeah, it's 10 years from their original sentencing.
So, yeah, see,
I
I
was gonna ask the same question, but I actually did do some research as well, and I came up with the 10-year being that magic number of which they allow people to be forgiven, let's say, in the persona of it. So it's a tough place to be. Do you let felons in? And I say convicted felons, as long as they've met all their requirements. 10 sounded high to me. I also did some research and I came up with the same conclusion, that was more acceptable. Is it how I feel? I'm a little torn about it because it's a long time, but it also depends on the felon. If you're a felon because you were convicted of stealing in the financial end of it, that's not where you want to bring them in to make the decisions for the financial of our corporation either. So it's a tough number. I didn't agree with 10 at first, so I decided to challenge that and go look myself.
Yeah.
And I really came up with that similar conclusion. But that was just my research.
And I'm willing to accept the friendly amendment. It boils down.
we're not there yet.
Okay, but it boils down to risk.
Yeah.
It's in the discussion. It boils down to risk. And certainly based on what they said, I personally, looking at these numbers, sure wouldn't accept 3 years. Might I accept 5? Yeah, with the understanding that here's the risk involved with it.
And then all restitution and
Right.
everything again.
Because, yeah.
Right?
And I think the most important thing about this is, to me at least, is to take emotion out of it, because our primary duty is to protect the corporation.
Agreed.
Okay? And personal feelings aside, I mean, I'm not going to say any one specific person is going to do any one specific thing at any one point in time. But at the end of the day, these numbers don't lie.
Right. Doug?
So good discussion. So, clearly if somebody came up to you blind and said, would you hire a felon on the board? Obviously, that's kind of what we're dealing with right now. But I'm glad you just said what you did, Frank, because the idea was listening to your numbers and it seemed like after 3 years, some of the data indicated that things went down, the risk went down. I'm not going to use the word significantly, but went down. I guess my other question, and I don't think it's gotten answered, or if it got answered, I apologize for not understanding it. We're talking about 10 years from the time when the individual was charged, 10 years from the time when they were convicted, or or 10 years from the time they've paid all their restitutions associated with the incident itself.
10 years
Which
from
is exactly
conviction.
the question I asked.
10 years from conviction.
10 years from conviction.
Okay. So to go back through that, it's at the, what additional risk would we incur if we went 5 years, seeing that you said you might think about 5 years, so I'm going to play off of that. And we would go 5 years from conviction. And does that change anything in your thought process?
Well, no, here's the only thing it would change in the thought process. The risk goes statistically from 1.8% to whatever that chart would say it would be after 5 years, which, and all these numbers drops down. And by the way, okay, also, and I think this has to be in full disclosure. Okay, when you look at that, this report from the Department of Justice is about 60 pages long, and it slices and dices things like you would expect from the Department of Justice. So, and this is why felonies, and I guess I have to discuss anything that has felonies in it. This is why felony is different and has been broadened to felony on the board member and somewhat reduced on the spouse, okay? If you look at the crime, for example, a drug crime, okay, the recidivism rates for drug crimes are extremely high. For violent crimes, they're extremely high, okay? So if you're dealing with somebody that, was committed with one of those on the board, the chances of that happening in 5 years are much greater. If you're looking at other less crimes that are federal offenses, the chances are much less, and the 5 years makes more sense. In saying that, I would point out one difference. The number 2 ranked crime for recidivism rates going high are financial crimes. So, you're dealing with that situation. But 5 years to me, I'd be fine with it, okay? I mean, again, because we're putting in front of the people, and 8,000 people may not care.
You just answered the next question I was going to ask.
8,000 people.
Let's not lose sight of the fact that the membership is going to vote on this.
Right.
I wouldn't want to just give them 10 years, let them suffer. And then they might go, no, and then we have no provision and we could hire a felon. Okay. So the idea would be put it out in front of the membership for them to understand exactly what the different conditions are. This discussion, hopefully for some of the people who are trying to make this decision made sense to them. And maybe the idea of 5 years might have a better chance. I can't predict that. I don't bet, I don't gamble, but, logic would dictate that you at least consider the idea of, 5 years from the date of conviction there might be more of an appetite for that. It's just speculation.
Amy? I really think we have to add the language like Florida did about it's after all the terms are met. Because otherwise you're going to have a sex offender who's on the sex offender list for 25 years on the board. 10 years isn't going to take care of it. 5 years isn't going to take care of it. The Florida statute, and I have that number if Jeremy needs it, that's why they did it. I read all the research. That's why they did it. They felt strongly that it wasn't a date of a conviction. It wasn't when you got out of jail. It was when you met all of your terms, whatever that was. So my friendly amendment would be 5 years after all the terms are met, including probation and restitution. And I think that it gives people a chance to run after they've done their time and they've made their restitution, and it protects the board.
I would be perfectly fine with that.
Okay, I want to add one thought, and that is that people don't commit felonies by accident, right?
Right.
They make a choice that some rule or another is not important enough to them to follow. And it may be for a variety of reasons, maybe, an addict, has gotten on opioids because of a legitimate illness and the problems that we've all learned about with opioid addiction, cigarette addiction, It's the same thing. They were manufactured to cultivate addictions.
Yes.
But other types of crimes, you're making a choice that the rule is not important enough for you to follow. Our job as directors is to make sure people are following rules. We need to be respectful of rules. And, I was talking this over with my husband, and he's a member of the National Watch and Clockmakers Association. They don't allow felony convicts of any duration on their board of directors. Why would, and none of those, they don't have the kind of financial fiduciary responsibilities that we have. So, I'm thinking that maybe, we're setting the bar too low here.
I don't disagree with that. I'm looking at it more of the layman being in the background that why would I need, like, for instance, FBI background? Why did they do a background check? I had to become an American, so to me, that was an automatic, had to be done. If anything was to come up, it would be flagged, right? But in today's terminology, I want to buy a mortgage, for instance. I go to somebody that's had been background and vetted and checked, and I'm asking them to borrow me some money to buy my home. Now, that person now takes me for a ride, takes my home, steals my money. I don't know. Then here we are moving forward. Now we're saying they're okay at getting into our board. They're kind of not, because they wouldn't pass an FBI background check. So, and with the FBI background check, they would also instill a certain timeline. Data proves. It would all be based off of data. So that's why I did my research, because I thought 10 years, Frank, come on. But then as I got into it, I'm really on the line with this. So I really appreciate discussion, because it made me bring it back home to, well, if we now allow this cup to come in and be the director, because it's the most popular one that we have, and that cup took my mortgage or whatever, how long do we punish them? Well, it's not really a punishment.
We're not punishing them.
Exactly. We're asking them to take. Agreed. We're asking them to take care of our financial pot. Right. So that's where I'm. The year, to me, at first I thought, oh, geez, now, but after doing my research, I need some help trying to figure out what would be appropriate without not insulting thy neighbor, but.
Yeah, Frank, if you're saying that the data is reflecting 10 years after sentence served,
No, 10
all the
years after
terms are met.
conviction.
Yeah, see that?
I'm with
They
you.
could still be in jail.
Yeah.
10 years after conviction. But here's the thing. Well, they talk, obviously, yeah. But here's the thing I like about the friendly amendment, okay? When you talk about after conditions being served,
Yes.
right? So let's just say hypothetically that you have a probationary period of 3 years. You're talking 5 years after that, after conditions have been met. You're actually talking 8 years, okay? So let's say you have a probation period of, it's some kind of innocuous thing, okay? Of it's 18 months, and you meet the and then it's 5 years after 18 months. Let's say you're a registered federal sex offender. It goes for your whole life. You'd never sit on a board.
Right.
Right.
Okay, so I think that the period of time, 5 years after you have fulfilled the obligations of your sentencing,
Yes.
I think makes a lot of sense, because if people go 5 years, it may not be the 1.8% that's in this report, but clearly over time, okay, that drops down. And clearly, if you look at these, unless it is the most minor offense that I can think of, okay? Let me give you a minor offense, okay? Your kid knocks a ball over the fence at NSA and you climb over the fence to get it, and all of a sudden you're looking at 16 armed guards, okay, who charge you with trespassing, and you go in front of a judge and the judge says, hey, it's probably not smart to jump across that fence when it says deadly force authorized, so I'm going to sentence you to 6 months of probation, no jail, okay? 5 years after that, you can go, if with a clean record, you can run for the board again, and that's a minor offense that shouldn't keep anybody off for an extended period of time. But I think that we've fulfilled they fulfilled their obligation to the law, and we fulfilled our obligation to protecting the association as much as possible. Same example, the stupid idiot jumps over the second fence again. If they don't shoot him, okay, he'll go to jail for a long time.
Well, and, I go back to the choice that you make when you decide a rule is not important enough for you to have to follow. In that 10 years, you could also be learning how to get away with it.
Oh, yeah.
Next time. And so it may be a conviction, you may have served your term, but you've gotten better, perhaps. I just feel once you make that decision that important rules, federal rules, are not important enough for you to follow, that 5 years is way too short. I would compromise on 10, but, for my money, I think once you're a convicted felon, you probably shouldn't be in charge of our money.
So if it's 10 years, you're saying it would be 10 years after all your terms are met versus 5. I understand what you're saying.
Doug, what are your thoughts? I see the squirrels running. Talk to me.
So, a couple of things, and I have to say this the right way because I don't want it to come out wrong. But I don't want to overemphasize our involvement with the finances, okay? Yes, we make policy decisions, but we don't handle money or run transactions or do those kinds of things as board members. That's what the finance staff does. So I just want to kind of get, that's what's kind of.
But we can sell property.
Yeah, we can. We can. I know.
So that's financial.
All right. So the idea here, however, it takes 7, okay? Not just 1, okay? And I would argue that if there's 7 felons on this board, that's probably not a good thing, okay? So the idea here is you're talking about 1 vote, all right? So that would be my argument. But the idea here is that I don't want to get the public to, get the sense that we have a hand in the financial transactions at the transactional level. We're at the policy level, and I think that's important. And given at the policy level, and again, let me also say, I support not having a felon on the board, so don't take this conversation as going anywhere else. But the idea of 10 years, maybe it is, maybe that is the right number. But 5 years after the sentencing occurs, for every person that is going to take 10 years to figure out how to get away with it better next time, I would argue that there's folks that are going, this 10 years is really, I made a mistake and I got to be better. And I don't know if we have any data on that, other than recidivity, of there, and it drops off. I can't say for sure. I clearly think we should have some stipulation that a felon can't be on the board, but I'm still a little kind of in between on whether it's 5 years or 10 years, and what that number will do to the public who's going to vote on this. Okay, that's the key, because if we just say 10, they go, that's far too, and then we've kind of shot ourselves in the foot. Okay, but the argument on the other side would be 5, that's not enough, and they still may not vote for it. Okay, and that's what I'm concerned with, is that we put a number out there or some stipulation out there that people can digest, understand, and draw value from.
But that's the reason I like Amy's friendly amendment. The more that I think about it, Doug, and look, being an engineer and a business guy, I look at numbers, okay, and numbers kind of rule. Mm-hmm. But here's what's very good about that friendly amendment, okay. 2 points. Number one, when you commit a crime and you go in front of a judge and they sentence you, they can sentence you to 10 years in prison based on the seriousness of it, 20 years in prison, 3 years in prison. That's all based on sentencing guidelines that now, let me back up a second. This relates to federal crimes. States are all over the board, okay? And, you can use 50 different states, but when it comes to federal crimes, every federal judge in the United States of America uses sentencing guidelines, right? The Department of Justice and the FBI rack up criminal points, and based on criminal points, they will go down and they will sentence you to 1 year, 3 years, 5 years, 15 years, okay? Now, if you're sentenced to 15 years and you serve the terms and you meet your terms, which could include early release, could include parole, could include, a release with probation, or however they do that, okay? and you take the friendly amendment, I think you've covered yourself, because clearly there's a difference between the crime that you commit, okay, and the type of sentencing. I mean, minor, property crimes, trespassing and whatnot, very short sentences on the guidelines, okay, and you're out very quickly. I think sex offenders are for life.
Well, it depends. There's
It
10,
depends.
15, and 25.
Okay, it could be a long time. Other crimes are in between based on the severity of the crime. The severity of the crime really does statistically track with recidivism. So, and our explanation, I think, to the voters, and the reason, again, I like really, the more I think about it, like the friendly amendment, is that we are doing this to protect the association based on the available information that we have of a population of basically 1 million people. Okay? Is it going to apply to specifically to me or to you? No, because we could be plotting, okay, and scheming, or we could go completely clean and say, hey, I made a mistake and I'm not going to do that again. But we can only go by the best information that we have and not try to winnow that down to a person. And that seems to be the idea that Amy has seems to be the best one, because look, if the Department of Justice, if the FBI is okay with you going out because you've met your terms, then there's no reason that I shouldn't be okay with you.
Yeah.
And
I'm okay
let me
with
ask you another question about those, how they sliced and diced.
Yeah.
Okay. You said that drug crimes, high rate of recidivism, financial crimes, second highest rate.
They're high on the list, yes.
What's the 10-year recidivism rate for a financial crime?
I don't know that. It wasn't published in the statement, or if it was so deeply buried in the financial report, in their federal report, that I didn't pick it up. But I do know they said the same numbers that I gave you with recidivism dropped down to 1.8% after 10 years. But I don't believe.
But that's the
yeah,
the trespassing and.
Yeah, I don't know that they broke
stuff.
out, and if they did break out.
It could, conceivably accidentally happen.
Yeah.
One more thing, and then maybe we should move on. Just the idea, I do support the notion of the friendly amendment. And the second part of it is, we're spinning our wheels, we're kind of beating this to death. You know what? When somebody gets out there and gets their name on a ballot and they were a convicted felon who served his or her time, that's gonna, let the people decide that, okay? Let the people decide that.
Felon doesn't show up for discussions, then.
Oh, it'll come out, trust me.
So my preference would be a 10-year after all terms are met, but it's Amy's friendly amendment.
Well, my friendly amendment is to do what Florida did, eliminates felons for 5 years after all terms are met, including probation and any restitution.
I would second that.
Okay.
Okay. All in favor of the friendly amendment?
Aye.
Aye. Those opposed? None. That passes. All in favor of the motion as amended?
Aye.
Aye.
All in favor, it passes. Okay, the next one, Brian.
Okay. Motion to define candidate eligibility in bylaw section 5.02 felony spouse. To have council develop the appropriate wording for a referendum to amend section 502A of the bylaws to add a new subsection to read as follows. Section 5.02, candidates for election. Okay, if the spouse by legal marriage, civil union, or any recognized cohabitation arrangement of a director has been convicted in a federal court or state court of a felony offense involving any form of fraud, larceny, embezzlement, counterfeiting, forgery, money laundering, and or tax evasion within 10 years of the May 1st of the year in which the election is to be held.
Is there a second? I'll second it for discussion.
I'm just gonna be the frank. Yeah, I don't particularly agree. I don't agree with this, but I want you to convince me that this is good for our community and not targeting any specific individual. Why would we place this in here? Convince me, sir.
Fair question. Rick asked a similar question. So let me give you the background of this thing and don't write it down. I'll give you a copy of it, okay? And I'm gonna stick with my research and everything. First, I completely understand your sentiments, okay? The motions that mention the word felony are not intended to specifically target any homeowner in the community. The intent of this motion is to eliminate any possibility or perception that a known convicted felon has influence over the management and financial decisions of the association directly as a board member or through the influence of their spouse. Some facts. Our association currently has over $50 million in developable property, amenities that generate millions in cash, and $14 million in the bank. We also have a community that historically has not trusted any board or management team. I think we'd all agree with that. Okay. 3 years ago, former general manager Brett Hill and former director Dave Stevens publicly accused the association of widespread fraud, theft, and corruption. As a result of their accusations, $250,000 or so was spent on a forensic audit. The audit found absolutely no wrongdoing on the part of anybody within the association. The theft that triggered the audit, amounting to $25,000, was determined to have most likely occurred at a financial institution. During this time period, the employees in customer service, our amenities, and membership were routinely asked if the money being handed to them was going to the association or to pay their personal bills. This went on for over a year. It's well documented. It wasn't one person asking the same question at multiple locations. It was multiple people asking the same question at multiple locations. Okay? And you can feel free to talk with the GM. It's well documented. I want to ask you each as a director, given this information, how do you think the community would have responded knowing that a convicted felon was on the board, or if a board member was under the influence of a known felon, their spouse? Okay, let me explain the extent and danger to our association of this problem on a factual statistical basis. Okay, financial crimes have a significant impact on organizations' revenue. According to a 2018 PwC Global Economic Crime and Fraud Survey, 49% of the respondents said their companies had been victims of fraud or economic crime, up 36% from 2016, while 64% of the respondents said losses directly due to fraud could reach at least 1 million. Okay. In addition, 46% of the respondents to the PwC survey said their organization spent at least the equivalent or more on investigations or other preventive measures of what they directly lost to fraud itself. To wit us, we spent $250,000 investigating a $25,000 theft. Okay. And 52% of all fraud is perpetrated by people inside the organization. Now, I want to point out, this PwC Global is a global consultancy that basically operates in every country of the free world, including the United States. So this, again, is a broad-based statistical thing. Okay. Okay. We all recognize that spouses have varying degrees of influence over their mates. At one extreme, the influence is minimal. Okay. My wife told me, don't put this damn motion in front of the board. I said, I'm going to do it. Okay. At the other end, the spouse does exactly what they're told to do, how they're told to do it, and when they're told to do it. And in our married lives, I'm sure we've all run into both types of influence. Here's another statistic that shows the potential risk. It comes from the United States Department of Justice. It's the statistics that I broke out of here and read to you earlier. Okay. That resulted in a friendly amendment. Okay, so these crimes don't go away. Let me give you another example under federal law, because one thing that I've heard, and quite honestly, you've raised the issue, Rick has raised the issue, I think Doug's raised the issue, you're impugning guilt on somebody, okay? And that is not the right thing to do. Well, I'll talk with you about impugning guilt. There's a federal law called misprision of a felony. Okay. Most of us don't even know that law exists. Jim might know in the audience because he's an attorney. Let me tell you what that means under federal law. if you and I are married and I commit a crime and I'm engaged in a crime, you can be aware of it, okay? I can talk with you about it and give you the imminent details of that crime, intimate details of that crime, blow by blow. If you don't reveal that to another outside third party, or you're not complicit in hiding that crime, under federal law, you will not be questioned under the spouse privilege, and they will not prosecute you. So you can be fully aware, fully discuss it, and as long as you don't discuss it with a third party and you're not in any attempt hiding it. And hiding it would be this. FBI agent comes up to you and says, are you aware of the crime? And you say, oh no, I'm not aware of the crime. I mean, I don't have the slightest idea of what you're talking about. Okay? That would be hiding the crime. If FBI agent comes up to you and you have half a brain, the first thing you're going to do is say nothing until the attorney shows up. The attorney is going to say, don't answer that question. You will not be prosecuted under Department of Justice guidelines. And that's the problem, okay, with the spouse of being a felon. Okay, they can influence, and from the above, you can see that the danger of having a convicted felon on the board or a board member under the influence of a convicted felon is both real and it's ongoing. The law is the law, the numbers don't lie. And this is one of these issues where I think we have to put it in front of 8,000 people, because I agree with Doug, okay? We are not day to day back in the finance office, okay, doing transactions. And I 100% concur with that. There's another aspect of it, Doug. I can go and ask the general manager to completely explain to me the process that we have, and they will explain to the nth degree any one of our processes that makes me familiar enough to circumvent it. As an honest person, I wouldn't do it. As a criminal, I might very well do that.
I hear what you're saying. I wouldn't, as a voter, I wouldn't want a spouse of a felon on the board, but I did research and I can't find one other HOA anywhere in the United States that eliminates a spouse. Most professional registrations don't ask about spouse felonies. If you have a spouse who's a felon, you can still serve on a jury. A spouse conviction might affect your security clearance, but it doesn't eliminate it. It might affect if you can have a gun. It could bar you from being a police officer, might bar you from military housing. One of the clear definites that it does bar you is you can't be a parole or probation officer, which I found interesting. But my main problem with this is it doesn't eliminate your problem. And the reason I say this is because you're going to eliminate the spouse. My spouse and I have the relationship that we don't have that much influence on what each other do. But I feel like I have a lot of influence over my children, my sons, and they have a lot of influence over me. So now let's go to the hypothetical that I have a convicted child felon. This doesn't do anything for that. And I feel like that risk is probably even greater than the spouse risk.
Yeah.
So when I take this into account, I don't think all the risk can be eliminated. I think that it is something that we're going to have to leave up to a very informed voter pool, and that they're going to have to make this decision when they're voting.
Right.
I mean,
By the
when they're
way,
voting for the candidate.
When they're voting for the candidates, we're going to just have to hope.
So how would we know if the candidate has?
I don't know that, but how do you, how, again, I go back to the risk. How does it eliminate if my child's a felon?
Well, let me address a couple of,
Okay.
let me address a couple of points, okay? So in your research and in discussions with counsel, and I think that Jeremy has said, let me give you the history of this thing. Originally it was written felon. And he said, way too broad, way exclusionary. I mean, I think you're going out of bounds with this thing. And he said, narrow it to financial crimes. and he talked with a former federal prosecutor to narrow it to financial crimes. So let me take one big population out. The reason you don't see, you said you don't see this in homeowners associations.
Not one.
Right, but I want you to remind you, we are a corporation, okay? And the reason you don't see this in corporations is they don't put felons on the board. And if their spouse is convicted of a felony and they're a senior officer, they're terminated. And if they're a member of the board, they're told to resign or you will be removed. That's why you don't see it in corporations. They handle it immediately, they handle it swiftly, and they handle it before it comes before the public eye. Because I can tell you, you name any one of the top Fortune 1000, they're about as interested in having a felon influence on their board as they are having to dance with snakes.
I got a question or a comment. I agree with the conversations going on with Amy, Frank. It shows that I do have just one thing, risk to us. I think it opens that up. I think it can be
Risk of us being defined as
legal.
us. Who is the us you're talking about?
Yes, the association or challenged, I should say.
Okay, the association.
The association. I think it could be perceived as discriminatory. I'm just putting my other hat on when I'm looking at this. And I just think we have to maybe get more legal interpretation on this, because I do care about risk with us in this amendment. You know, as far as being discriminatory, I get, you know, the conversation we had previously with the 5 years of somebody actually being on the board, that person. But I can't support the piece of a spouse, because we don't know that we're putting opinions. We're putting what may happen. We don't know what happens. We don't know. And that's where I think that that it will impose a risk to us as an association, as a board. And I believe it can be perceived in my thought as discriminatory. We do that.
Sure.
And so what is the discriminative?
Leaving somebody out, somebody who could be a very good quality candidate, whoever it may be, because of an action.
Not a protected class.
But as somebody else.
Right, but we're not talking about a
No, we're not talking about
protected class
protected
that's
classes.
legally protected.
Yeah, legally. So that's my thought process on that.
Understand, can I respond?
Sure.
Two things. Number one, this amendment would have to be a friendly amendment to again reduce it down to 5 years after the, okay.
Probation thing.
Yeah, 5 years after that. And second of all, we've discussed the issue, Rick, that you're bringing up about legal risk and challengeability and stuff like that. And I think maybe Jeremy should chime in, because I rewrote this thing several times based on his input, not to eliminate risk, but to minimize it.
Jeremy?
So I think the last email that I sent about this, I did identify what my concerns with this particular amendment were. While the reducing it to financial crimes, it is intended to address the sort of the puppeteer aspect, I guess, is what we're talking about, is that one spouse is sort of assisting the other spouse to, help with figuring out how to cheat the system, steal, embezzle, whatever that would be. My concern remains a little bit that if they're reviewing this amendment based on a reasonableness standard, the question is whether this would be considered as arbitrary. What is the connection between the spouse and the actions of, the spouse's actions on the spouse? Now, there may be a connection that we could do and articulate to a court. But I think that, echoing Rick's thought is, yes, we've reduced the risk and tried to eliminate it. But I think of all the amendments, this one in particular presents the greatest stretch of sort of the reasonableness standard, if that's what the court ends up doing for it, and creates imputes the actions of one spouse on another based on a hypothetical or something that actually proved would happen. That was sort of where concerns of this amendment came to pass, and I tried to articulate that pretty strongly in this correspondence. But I do believe that the way it is drafted is We're not really talking about the, if, I vehicular manslaughter and I kill somebody, God forbid, with my car, that has no relationship to my spouse, right? She had nothing to do with that. That was totally my action. Here, the financial is sort of where we're trying to tie the nexus between the two. And I think that, echoing Rick's comment is I do think it is on the boundaries of what a court may find reasonable if that's what they end up using as the standard.
Doug?
Yeah, again, good conversation. This is the kind of thing that I was hoping that the people that are participating in this meeting virtually and that will watch the recording later will understand, the kinds of things that we're considering. I can't support this for a number of reasons. Some have already been stated. The other is the concept of influence. In other words, I've heard where a spouse who's a convicted felon could influence, a director on the board. Well, how is that any different than, let's say, you have Uncle Joe. Uncle Joe owns a construction company, and Uncle Joe finds out that there's land for sale, in Ocean Pines that would greatly benefit his company, and he would exercise undue influence on said director, to try and make sure that he or she, as a director, did whatever they could to push that forward. How is that any different? It has nothing to do with felon, has nothing to do with spouse, has everything to do with influence, okay? So if the premise of this motion is based on influence, then, we can shoot it down, 15 different ways from Sunday. Another thing, just for consideration is, guess what? We all get influenced. We only get one vote. All right. So one person gets influence does not automatically mean that we're in a world of trouble because of that. OK, yes, that person may to try to convince or persuade his colleagues, to do that. But I don't think it puts us in any more risk than we have day to day, in dealing with things. People come, hey, I really hope you vote for this, yada, yada, yada. OK, that happens all the time as a matter of course. I'm far more concerned with the fact that we are introducing unnecessary risk to the organization. Our counsel has advised us that he's not, and I hope I'm not speaking out of turn, Jeremy, but he's not the biggest fan, or a big proponent of this. He's asked us to consider that there may be risks that might be unnecessary. So I can't support this. I won't support it based on, again, I just don't think it benefits the overall corporation.
So, thank you for your explanation. I struggle with this. Having a spouse that has clearance, I don't. How would it affect our relation? Does he have influence over me? Oh, hell yes, he does. Just as your wife would have to you. You got to be in a bubble to tell me that your spouse doesn't have an influence. It does. I mean, fall in love with somebody so there's that. I do believe there's a sort of an influence there. So this is where I was struggling, because if my husband says, honey, I really don't think you should be doing that, I'm going to respect him because of the individual that I am, and I'm not going to do that. But if he says, I think, hey, we could benefit from this, ultimately, blah, 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 set ourselves up for a great future. I'm not saying that I'm going to do wrong because I'm about the law. But if I was that 1% or that 2 that, this looks like the easy way around, possibly. So that's where I lay. I was totally against the whole thing even being brought up for motion. I really appreciate you giving me the specifics. Somebody's going to have to keep talking because I'm not quite off the fence.
Okay.
I'm unsure.
I haven't spoken. I have a problem with the influence part of it also. I think there, obviously, in my line of work, I've seen everything when it comes to relationships and have seen, influence. But, in my experience, the measure of the person is what is presented to the candidates. Presented to the voters when you become a candidate. And the voters take your measure. And if they're not doing a good job of taking your measure, that's that's a problem. It's a problem for all of us, but that's democracy, right?
Right.
You do the best you can. You try to get the information you need to take the measure of the person. And, I think, is there a 0% likelihood of a felon influencing their spouse? No. I mean, we know there's going to be people that are influencing, but I don't think that, I just don't agree with setting a policy for that 1.1% of a chance that that's going to happen. I'm sorry. I mean, I think it's certainly something that we should all be aware of. And I think having the, if the felony candidate passes, I think that would be a good thing, because I think in this day and age with what we've seen, there's, we need to protect the association from that. But I think we're getting down to kind of minutia, minute risk. And I think, Doug and Rick and, Amy and Jeremy have raised the idea of the risk to the association of having this, of passing this motion. And I think I'm more concerned about that risk.
So you're saying that if we chose to be a candidate, we can spread it to the world that, hey, did you know their spouses, but don't.
No, but that stuff
You know what
comes
I'm
out.
saying? I know it
Yeah.
comes out.
Yeah.
But
Yeah, and I think it's not just that your spouse is a felon, it's your integrity as an individual.
exactly.
And
I mean,
think,
it's a lot of
I can
millions.
tell you, if my husband committed financial crimes, he wouldn't be my husband anymore.
Thank you.
And if, I love him, but, that's not the kind of person I married, right? And so you take the measure of the person, and that tells you what kind of choices that person makes and how malleable that person is. And if you see the person is malleable, their spouse could be a felon or not. I'm not sure you want them on the board anyway, because you don't want them flopping in the wind on stuff. You want them to have a central core of integrity and ego strength that allows them to make decisions based on facts, data, and what's right and what is consistent with the rules. They're not going to be influenced by friends, children, uncles, spouse. You're taking the measure of the person. And, I would hope that people listening here would, accept that responsibility. That, your job as a voter is to take the measure of the candidate. And, let's get good people on the board who are people of integrity, who respect rules, who are not malleable.
That we don't even have to be discussing this.
Exactly.
This is what
So
bothers
that's
me.
so I just don't feel like I could support this motion for that.
No, I mean, I certainly respect the discussion. I think the risk is real. I understand the other risks that we're talking about, and I'm certainly willing to withdraw the motion. But I got to tell you, I really do feel better, and I want to address specifically about risk. And I'll be perfectly honest. I would not vote for this motion if the 7 of us were here to change the bylaws. Because 7 of us saying that we don't want the spouse of a felon on the board is highly restrictive. It would, I think, step across all kind of legal boundaries that would put us into very great risk. Go back to every motion here. We're going to send out 8,000 ballots, okay? We're going to get 4,000 back, right? I think if 2,500 of those ballots say this is a good idea, that mitigates our risk to a pretty big, to a great detail. Because at the end of the day, we are a corporation, and we're determining qualifications for our board. And that's the only thing I'm asking for. And by the way, I'll even go a step further. I think that's the only thing that we should, as a board, I don't think we should take a position on any of these. I think as a board, our position should be, this is something we're putting forward to you as a member of a homeowner in this corporation, a stockholder. Do you think this is a good idea? If you think it's a bad idea, vote the damn thing down. If you think it's a good idea, vote it up. I'm not encouraging you one way or the other. I'm just telling you, this is the reason. To keep known criminal influence as far away as humanly and legally possible from the management and financial decision-making of this corporation.
Yeah, Frank, I think it's all well and good to say that we not take a position on these. But I think, like all elected officials, the membership expect us to vet things. And, voters expect their representatives to vet things and to, take some kind of a position on things, not just put it out there. They want us to do the work. That's why they have us, so they don't have to do that work. And so, and whether we publicly take a position or don't, I think that the motion would pass paints all of us with the brush of, this board thought this was a good idea. Some people will vote for it because this board thought it was a good idea. Some people will vote against it because this board thought it was a good idea. So I think it's unrealistic to think that we're viewed as that objective, that we're just presenting this without a perception of influence.
Agreed with that. This is not up. My whole perception is I wanted to run as far away from this as I could and hope that we wouldn't even discuss it. But is it better suited to put in front of the people to say, instead of putting it on us, it is their association. Do we say, well, help us make this decision? Is it that important to you? Or are we way over our boundaries? What are you? I don't know.
I feel we have a higher duty of care. I'm hoping that I spent many, many more hours than the people, the homeowners researching this.
Right.
So I do feel we have a higher duty of care not to put things forward that do put us at risk. And I hear what you're saying about the corporation, but I mean, if you could have just found me one HOA in all of United States that had this, I would feel better about it, but there is none. So I'm going to have to be against this.
No, completely. I mean, like I say, I understand, but I do believe it should be, again, made by not 7 people, but by the majority of 8,000.
But the majority, that's my thing. I feel like I have a higher duty of care sitting here than they do. So they might not have researched what other HOAs have done, whereas I have. So I feel like I have a higher duty not to put things forward that would put us at risk for a future lawsuit.
But the duty of care might change if you researched corporations instead of homeowners associations. Because the duty of care, the way that I look at it, is to keep that influence away from the corporation.
I hear what you're saying, but I mean, if I have a spouse who's a felon and I can still get security clearance and I can still serve on a jury.
I'm not so sure about the security.
I researched it. I researched it. Yep. I mean, basically the only things I can't do is marry, is be a parole officer and a probation officer. I mean, I did the research. So I think it's a stretch to say you can't be on Ocean Pines board.
But let's clear one thing out of duty of care. Okay, if your spouse is a felon, you're not going to get a security clearance until you go through the interview process. And I've been through that interview process and sat across from a guy that worked for the CIA for 8 hours. And if it comes out that there's any smack of influence on your decision making, you will not get the security clearance.
Agree with that.
That's a very complicated process.
Okay, so do we feel like we're ready to vote on this? Have we heard?
Well, did you officially withdraw or not?
Yeah, if it's not going to pass, I withdraw it. I mean, don't want to put you into a position of voting for or against, but I would just say.
You want a discussion, and I'm glad we discussed it.
Yeah.
And it's a really a difficult one to analyze as a board member. We all agree to that. This is a difficult one. And my first instinct after hearing the statistic, because I'm on the other side where someone has a clearance and et cetera, and I'm in the back of the line because I don't, and I'm in whatever, right? So, but I totally respect that. And I know what it took for him to get that clearance. And you swear of oath that when you become an American citizen that you are not going to be placing yourself in any of these situations. That's just the way it is. So, so I don't know, do we leave it to the populace to talk about it, or do we handle it?
No, we handle it.
We handle it.
I'll withdraw. I mean,
Okay. Okay. We all agree?
in fact, so anything that then mentions spouse with felony will be withdrawn,
Okay. Thank you.
okay?
Okay, the next motion, Frank.
A motion to define candidate eligibility in bylaw section 5.02A pending litigation. The candidate may not be a plaintiff in an active lawsuit in Maryland or federal court, including on appeal, in which the association or any of the association's directors named in their capacity as director are named as a defendant, nor may any candidate be named as a defendant in an active lawsuit in a Maryland or federal court in which the association is a plaintiff, including on appeal.
I'd second that.
Okay, Josette, discussion? Doug?
So Frank, I'm following your thinking, is there a distinction between a suit that involves Ocean Pines and a suit that doesn't involve Ocean Pines? In other words, said individual who's.
If you're sued privately, it's you're sued privately.
Okay, I mean, because the idea would be, and it comes out later that you were involved in some sort of litigation that had nothing to do with Ocean Pines, would that individual be questioned if he or she had already been elected to the board?
Yeah, I mean, your dog bites somebody and they sue you. Okay, you're free. I mean, this whole idea here, Doug, is to prevent first two things, to prevent an active member of the board suing Ocean Pines.
And then running for election or run for election.
Well, you can sue them beforehand and you can sue them after, but not during, okay? And the second thing that it prevents is somebody suing Amy and Josette to knock them off the ballot as a candidate, okay? So it just, in this narrow confines here, before, for example, just to be very specific, if former Director Trendick wants to run again, he's would be eligible to run again under this amendment because he's not in an active lawsuit against Ocean Pines. Mm-hmm. Okay? If after my tenure, I sue Ocean Pines because my house is flooded, up to the rafters because they haven't maintained a ditch, I can still do that and it doesn't affect the board. It's just in that time period basically of candidacy and on the board, the plaintiff and defendants, and when Ocean Pines is the other party.
So, and going back to, and you guys probably don't have this issue, going back to our discussions from a couple of years ago where B08 was weaponized.
Yes,
okay?
It was weaponized.
You remember that? It was weaponized. So the idea would be, could there a situation arise where a lawsuit gets brought up as a preemptive strike before someone, then they find that someone's, going to run for the board. In other words, you're weaponizing this as well. Guess what? I can sit there and go, well, you know what? I'm going to, I don't have a real clue, but I saw Amy's car bumped into mine, and so I'm suing her.
So like
Okay.
May 5th, you
Yeah.
bring, is that what, is that your?
In other words, I go right before
Okay.
guess what? I'm going to sue you because you bumped into my car. Okay. Well, we just weaponized that particular thing. We made it so that, I now have a vehicle to prevent her or anyone else from running.
Well, that's not how
And I just.
that doesn't have to do with the association.
That's why I want you to explain it to me, because some people will perceive that. Go ahead.
Jeremy?
Can I
Yes.
answer that?
Please,
So the way
please.
the amendment is drafted is the individual director has to be named in their capacity as director. So in the last two suits against the association, the individual board members were sued in their not in their individual capacity, but as directors, not for a separate issue that has nothing to do with Ocean Pines. So using your car example, that would not trigger
Okay.
this particular amendment. The idea here is, I think, is that if you're actively suing the association, you should not be able to be elected for the board of directors because of one, you are suing the corporation that you're seeking to now serve, and then if you get elected, it creates all kinds of issues if that happens.
Sure.
And the other issue is, if the OPA is suing you for a covenant violation for failure to pay assessments, which would automatically disqualify you anyway, but for if you are in breach of the governing documents and we are suing you, this would prevent you from suing. And then now all of a sudden we have a suit against you and now you're on the board and we have to deal with that implication. So the idea here is if you're adverse to the corporation at that given moment, then you cannot serve, you cannot be elected to the board of directors. I think there's been several versions of the amendment, and this is the last one that we landed at based on a bunch of hypotheticals. But Doug, just to be clear, in your individual, now, there is the potential, of course, that OPA could file suit against a candidate out of bad faith, right? I mean, just sue them to try to block them from candidacy of the board. Well, they would have to first find a lawyer that's willing to bring a lawsuit that is illegit, that doesn't have merit to it, right? And then they would have to deal with those implications. So, it would be a problem for the association to obviously weaponize a complaint to be brought right after the eligibility period began. Does that make sense?
Yeah, and I understand, the capacity. I guess I'm just trying to prevent the notion that, well, again, it'd have to go through a lot of, hoops and everything to get to a point where an attorney would, sort of say, hey, let's take this frivolous lawsuit, let's get it on the docket, and then withdraw it later on after the election, with the sole purpose of preventing candidates, from getting on the board by naming the entire board,
Well, and then the corporation could be there's potential response to that. If you bring a suit in bad faith, the plaintiff can be held liable for attorney fees and several other things, and sanctions by the attorney, but the attorney technically could get sanctioned too. So it does. Again, you would have to find a lawyer willing to bring a case that is clearly without merit and just for the purpose of subverting the qualification issue.
Yeah, and I just don't see how, for me, the issue is divided loyalty. Who are you loyal to, your lawsuit or the association, right? And this says that either the individual, the would-be candidate, is suing the association or the association's directors. And so how can you comply with your duty of loyalty to the corporation if you get elected, if you're doing that? And the other one is if the association is suing you, the association can't bring a lawsuit based on one director deciding, I don't want that guy to be a candidate. That would be something that would have to be agreed to by the board. So I think the risk of that frivolous lawsuit thing is pretty low.
I mean, I'm in support of this because conceptually, I understand what it's trying to do. I just look for those outliers, those things that, that you have to plan for that probably have statistically irrelevant chance of actually happening. But the only thing that's absolute is zero. Okay. Anything above that,
spouse,
okay,
which is,
anything above that is a possibility that you need to consider, however small the, actual, relevance.
But it seems inconceivable that situation could arise at all.
I agree with you. I'm just saying, just be very careful.
That's kind of where I am. I think that this has merit because of the divided loyalty. How can you serve both masters? You can't. So any other discussion on this one? Okay, all in favor of this one, say aye.
Aye.
Aye. Any opposed? So this one carries. And now we're up to another one.
Okay, motion to define candidate eligibility in the bylaw, section 5.02A, reformatting of existing language. Section 5.02, candidates for election. The candidate may not be an incumbent director completing a second consecutive elected full term of office.
So we covered that in another
Yeah, it's another,
motion.
it's in the bylaws. It's already in the bylaws.
Okay.
You have to, wait a minute, you have to officially withdraw. You have to officially withdraw.
He just said he was going to withdraw.
Okay.
I just said, yeah.
Okay.
And then this next group have to do with candidate verification, so I just got to keep Jeremy on the line here in case we need him for these.
Yeah, because before I forget, we also have to add a motion
At the end.
at the
yes.
end that,
So I think we'll need you to the end then, Jeremy.
and can I speak to Jeremy a second?
Yes.
Jeremy, the motion that I'm going to add at the end was advised at the beginning of the session, and that is to make sure that any of these that are applicable to appointees, that is put in the bylaws.
You were in that conversation, weren't you, Jeremy? That we discussed that
Yes,
these should
so
also apply to
we think it's,
appointees. Yeah. Okay.
Can you develop some appropriate wording to give me some coaching when I make that a motion?
I'll do that while you're talking about these other things.
Okay, thank you. Okay.
You got it.
Listen with one ear.
Or we'll take a break.
Yeah.
Okay. Motion to define candidate eligibility in bylaw section 5.02B. Candidates for election. The eligibility requirements for election to the board of directors are as provided in this section. Search committee. No later than February 1st each year, the president shall, subject to willing volunteers and to confirmation by the board of directors, appoint a search committee of not less than 5 members of the association eligible to vote. The committee shall solicit candidates for election to the board of directors. The committee shall attempt to acquire at least two more candidates than the number of vacancies to be filled on the board of directors, including any unexpired terms. The lack of a search committee or the committee's inability to acquire at least 2 or more candidates than the number of vacancies will not affect the validity of the election. The committee shall submit a list of candidates to the secretary not later than May 15th and to conduct such referendum.
Is there a second?
I'll second.
Okay, Doug. Discussion?
I
Doug?
just have one question. It's more kind of, the term, you're adding the term willing volunteer. I don't know, is there such thing as an unwilling volunteer? That's my only point. I totally agree with the fact that, you know, the change, the lack of a search committee has no effect on the validity of the election. I fully agree with that, but I'm just trying to figure out the logic behind a willing volunteer. So if we don't get willing volunteers, then is all this, you know, just kind of go up in smoke?
It's kind of like the military.
Yeah.
Well, I think it's the acknowledgement, excuse me, that you may not get volunteers. And
all right, no, I don't have a problem. It just struck me as, I've never seen the term
It's like an oxymoron.
volunteers, you know, in contrast with unwilling volunteers.
But
like
by the way, you
oxymoron.
know, Doug, the wording came from council, and this is another one of these things that I don't think in a million years we'd ever spend $28,000 on a referendum about.
Yeah.
But it was brought up in a legal context.
That's fine.
Okay.
I'm off.
You know, we should plug all the holes that were, when somebody says you have a hole in the boat, we should plug it.
Yeah, fair enough.
Mimi, did you have a
Okay.
comment?
No, I'm good.
Okay, so we did have some discussion earlier about making the search committee a standing committee, in which case annual appointment would really not be a requirement, I guess. I mean, I don't know how this would square with that concept, or if it's maybe not even a good idea to have a standing committee. I don't know. What are your thoughts?
You know, having been, you know, number one, we've conducted elections without search committees. Okay, so are they an absolute requirement to the whole process? No. You know, is it good to have? Sure. And I remember in our last meeting, I cited the fact that several years ago, a bunch of the candidates were there, and they invited me when I was president to come in and, you know, be available to ask any questions to, and hey, what's it like being on board, so on and so forth. So that was a benefit, but certainly wasn't, not having that wasn't a deterrent. I think I like the way this is put together. I think and the change of saying that even if we don't have a search committee, it doesn't change the validity of the election, covers everything. And I just think that having a standing committee that'll be, dormant for 9 months, let's face it, and then, have some activity for the last, 3 months of the year, you're probably not going to get the kind of volunteers. I think it's with this, the president appointing a point in time group of people who are focused for a short-term duration task is much better.
Amy, you had a comment?
I liked the standing search committee because I thought it gave consistency to the group if they were serving 3 years. So that was my comment with that.
And
versus 1 year.
I would be okay with either, but before I would agree to have a standing search committee, I would have to be pretty much assured that there are safeguards in place to make sure that it doesn't drift into what has been an overview of all of our discussions, and that is it becomes a tool of exclusion.
Yeah. And I guess my thought was that an advantage of a standing committee is to do kind of candidate development.
Yeah.
I
Which,
agree with that.
I think could be of value.
Residents Academy.
I would agree with that, but I would argue that you don't need a standing committee to do that. We could organize that activity through any number of folks at any point in time we wanted to.
Yeah. Or the other, option would be that these are renewable positions. If people get appointed 1 year, they could kind of nominate themselves to continue.
Yeah. There's and a standing committee under resolution CO1, there's term limits to the committees and so on and so forth.
Right.
I just think that it's, again, you get a focus group of people for a particular incident at a point in time.
Right.
And you're going to get the kind of participation you want. But to your point, like I said, if we wanted to have another activity where, you meet the board, open discussion forum, whatever, we can hold that. There's nothing preventing us from doing that. Quite frankly, I think it would be a benefit. We should be doing a little bit more of that.
Yeah. To that point, there's nothing to prevent us within the next, it's past February 1st, nothing to prevent us from asking to have a special event where we invite all committee chairs and committee meetings and talk with them about running for the board. Absolutely nothing. Absolutely nothing.
Yeah.
We have an executive council meeting and there's no restriction on the number of executive council meetings you can have in a year.
Right.
It's just,
bring the.
But I think also a town hall type format to invite the
You
public.
got a number of avenues. So
Yeah.
I guess,
So-
my point is, I prefer not to have a standing committee. I think this particular bylaw covers it.
Rescind bylaw. Robert's rules for a minute here. Suspend.
It's unfortunate that at the last of the December board meeting, on this issue.
Yeah.
And it's unfortunate that we never really got the opportunity to discuss the issue of the search committee because of intervening requests from the board.
Right.
We spent 2 meetings doing nothing other than really responding to the board on a particular issue, or the last meeting was effectively preparing our final proposals for this meeting. And it's unfortunate that the search committee topic was never discussed at the bylaws and resolutions committee level. There was a proposal circulated to the committee members, which the committee members saw, but again, was never discussed. And I'm compelled to make some of these comments on this, not only this motion, but the one that follows. I simply do not support this willing volunteers stuff. That kind of thing doesn't belong in bylaws. Beyond that, I am back and forth on whether we need a committee, a standing committee. Do we really need it? Well, we got to figure out some way of publicizing, encouraging, whatever terms you want to use. Leave out reference to the committee and create an advisory committee. You can tweak that committee, terms, members, duties, however, whatever way you want to, and if it doesn't work, put the committee aside. Now, let me move on from that. This business about two or more candidates. If there is a search committee, the search committee results are what they are. It is what it is. There's no reason to have two or more candidate reference in here for the search committee to have a target. If you have a committee and you're going to put and the bylaws do call for action by the board if there are not two or more candidates for the positions up. Put this provision about the two or more candidates there in the board action part, that you don't have it does not affect the election if there are not two or more candidates. Take it out of the search committee area and put it where it belongs, and that's in the board action part of the bylaws. This business about a committee in the bylaws currently submits a list of candidates to the secretary by the 10th. There is no reason for a committee to have its hands on applications. They should go directly to the secretary. I realize you have to have some means of gathering them for the secretary, and that is in fact in the M09 bylaw resolution, excuse me. But the applications go from the applicant to the secretary. And we have I'm going to continue on to the next motion. I'm sorry. I think it's appropriate to do that. An application form provided by the association. How provided by the association? And I don't mean website, newspaper, news articles, publications, whatever. We have the form at M09 so that it is a form that is fixed in time. It's not something that somebody can mark up and provide by the association. It should be, if anything, put a reference to in a resolution in the book of resolutions or some such thing like that. Again, I've talked about already, the form shall be submitted to the search committee. No, search committee doesn't have to handle the applications if there is a search committee. In any event, the application goes direct to the secretary and whatever proper means or whatever proper process is developed. And there is a process in the M09, although it involves again the May 10th. I don't know why we have the May 10th and the May 15th differential in the bylaws now. There could be any number of reasons. I'm not going to try to speculate on them. They go to the secretary on the 15th. Or if you want to make it earlier in some way, consider that.
Yeah, let me speak to that. One of the things that the judge brought up in the FAR versus OPA case is the secretary's gathering information to clarify eligibility. And the 10th, from the 10th to the 15th, which is when, no, I guess it's the 15th to the 1st of June, you need some time to do that. And you need, there is a verification date, by which all of this needs to be done. And so I think the idea there is to give the secretary some time to do that.
I don't have any difficulty with the 15 days to the whatever to June 1st, but there's no reason for this May 10th in there.
Yeah.
If you have
if it goes directly to the secretary.
If you have a search committee, the 15th. If you don't have a search committee, the 15th or whatever date we deem appropriate.
Yeah. Okay.
Now, I'll just make a side comment, kind of maybe on behalf of the elections committee. The elections committee in its report, which each of the board members should have, Section, two more recent appointees. The search committee, in its elections report that it issued in the last couple of months, commented about being a little bit compressed in the June 1st timeframe to the time when the materials are supposed to be ready to go out. There is a date in the bylaws regarding when those materials are supposed to be ready. Is May 15th the right date? Can you move it forward 5 days and move forward the due date to the elections committee? I'm just making that comment. If for no other reason, I have had informal comment, input from that. Would we consider it in the bylaws in our consideration? Anyhow.
Okay.
I'm going to just end my comment with this. These two motions need to be looked at. That's what we're going to just look at that here.
Okay, thank you. Okay, Robert's rules reinstated. So we're working on the search committee.
Yeah.
And so I guess the willing volunteers maybe is thought to be unnecessary.
Well, let me ask a question just in general, okay? So is Jeremy still on?
Yeah.
Okay.
Yeah, I'm here.
Okay,
I
so,
had to, yeah, go ahead.
so let me, about these, and I mean, again, these are, for me personally, I'm kind of agnostic because some of these were just, I'm the point guy on it, but they were given to me by other people. So let me see if I can accurately portray the legal situation that we're in with any of these bylaws, right? So we have a motion from the court, or we have an order from the court in the litigation that Rick brought to us, that as I understand it can be referenced, but it would not be part of Maryland law unless it was appealed and the appeals court ruled one way or the other. Is that correct?
Well, the decision, the court has spoken on several issues factually towards Mr. Farr's case. And so, yes, I mean, but it is not binding on future decisions that are different from the factual scenario in which the court came to its decision in that situation, if that's what's answering your question.
I think, well, here's the more specific question. So these bylaws have all been, not 100%, but ostensibly been crafted to address the situations that were specifically pointed out to us by the court. So if we do not change any issue regarding the search committee that this court referenced, okay, then the risk to us in any kind of future conflict is that we have to go back to the old bylaws because these would not be implemented, and we would basically could be facing the same questions. Is that correct?
That's correct. So what the judge in the Farr case referenced concerns about is a belief that more directors were required, even though the bylaws didn't require
Yeah, I
it.
guess
So you
we
have to
should.
go out, and if you don't have sufficient directors, then that could be challenged. And then there's a question about the existence of a search committee. If you don't have a search committee because we can't get sufficient membership to serve on the search committee, does that negate the whole election? And the whole idea, I guess, is that the individuals raising this amendment, and when we looked at it, was to try to contemplate those various scenarios. I agree with Jim that I don't like having the search committee codified in the manner in which it is codified in the bylaws. I would prefer it to be yanked out if we could, and just put it in in a policy that the board creates with the committee that is sort of a search committee / nominating committee. But that is the answer. The answer here really was
So Jeremy,
try to
would
resolve
mean
ambiguities.
so you would say put it in a resolution rather than in the bylaws.
That would be ideal, is to get rid of
Okay.
the mandated search committee and just get rid of it, because practically speaking, what happens? The call for nominations go out. right? People submit their nomination. Whether or not the search committee does anything doesn't necessarily relate to whether somebody nominates themselves or nominates somebody else. So practically, I'm not sure exactly what the search committee does other than potentially trying to communicate more to get more candidates. But that, and I'm not sure if we're ready to deal with that today, but that's the idea, I think, what Jim is raising, and I do support that concept.
But I guess my question, to be more specific than Jeremy, is if we don't address the known deficiencies that the court has put forth to us, then by these resolutions or by these proposed changes, then we are back to the situation of facing the same situations that they pointed out to us in the next election. Potentially.
Yes, that is absolutely correct. Those same things that were raised by the court could be used by somebody to challenge the election in the future. So the problem with any policy that you have in place is if you don't adhere to that policy strictly, it creates potential challenges. So that is always the issue you have when you have any policy.
Okay, let's identify the specific deficiencies we're talking about. We're talking about deficiencies. Okay. Let's enumerate them.
Yeah, so the deficiency was the number of candidates that have to be obtained.
I fully agree. That should be out.
That should be out, because what if only one person runs? Or what if only two people run and that's all they run? Okay, well, that's how it goes.
Okay, if you want to read the provision, it's in 502E. If the number of candidates on the list submitted to the search election committee is less than 2 more than the number of vacancies, the board of directors, okay? Forget about the search committee, whether it's a governing document committee or an advisory committee. If that's going to stay in there, put that qualifier that doesn't affect the election if they're not 2 more, put that in that provision there. In 502E. That's all I'm asking. Or recommending, let me put it that way. If we're going to continue to have a 2 or more requirement in the bylaws, then that qualifier belongs in the board action portion of the bylaws, not in anything having to do with candidate applications and search committees. I don't know if I say anything, so what's the second deficiency?
The existence of the search committee.
We don't have a search.
The existence, okay, fine.
The basic existence of a search committee. What happens if we don't have a search committee?
Okay, if it is not an governing document standing committee and an advisory committee, does that change the equation?
If it's an advisory committee, then the board can, through the board adoption process, can change the requirements more easily than through an amendment. So it could be more adaptable to what we're seeing on the ground, so to speak. How many people are out there? Or is this working? Is it not working? Tweaking it. Here there's less ability to tweak what you want to be able to do to make it effective for your desired ends.
Okay, I fully agree with that. If the problem is with a search committee as a standing committee, and we're concerned that may lead in one way or another to litigation in the future, get rid of it. And if we don't get rid of the concern there by putting in an advisory committee, don't put in an advisory committee. I can't really answer those questions or issues. I would look to you on that, but one way or another, make a decision. Can we have an advisory committee and not have problems? That would be my preferred approach, rather than the words we got in this motion, for example.
I guess the
The
risk.
answer is yes. The answer is yes. If we have an advisory committee and we create an advisory committee, we can, the board and with different boards coming into place can dictate what that committee's role is and what it is not. And, for example, it could be simply a marketing committee, right? It just could be simply is they will set up and attempt to market and explain the roles of the directors to facilitate individuals to submit their candidacy, right? I mean, we can draft it in very general terms that doesn't mandate anything, doesn't mandate a deadline, doesn't mandate things. So yes, we can draft it in certain ways.
Okay.
I will note that a recent change to Maryland law regarding nominations from the floor, which do not affect you, but what the new change to Maryland law says is if there are sufficient candidates to fill the positions, 2 candidates for 2 positions, then you're not required to take nominations from the floor. Obviously, you don't have nominations from the floor, but almost all other community associations do allow nominations from the floor in the bylaw. And so what I'm getting at is even under the statute, they're sort of recognizing that if you have enough candidates to fill the positions, that can be sufficient. There isn't a problem with that at a statutory level.
Okay, I don't want to divert in any manner the conversation, but in the existing M09 search committee resolution, we do give some degree of direction to the committee that they're to go out into the association and publicize the upcoming election. I'm going by memory of the words. But we do give some direction to the search committee in that resolution, and it can be changed, modified, whatever, to amplify on the words in the bylaws that say solicit, words to the effect solicit candidates for the election. We already do that.
Okay, so it sounds like if we go back to this motion we're discussing, that what we might do is take out references to a search committee having a role. And so each individual who desires to be a candidate shall complete an application provided for in resolution M09, which it already is. And it shall be submitted to the association secretary or assistant secretary. Does that?
That's the second one we're discussing.
Yeah, sorry.
Okay.
I jumped ahead.
We're still.
So I guess we need to go back to the first one. So yeah, I lost my place here.
See, and I would
So-
say, I think, look, like I say, I'm agnostic. I'm the messenger on this one. I'm perfectly willing to change this and accept the friendly amendment that does almost anything. But the thing that is absolutely necessary is to address the deficiencies pointed out to us in the recent litigation.
Agreed. And so it sounds like eliminating paragraph B could do that.
Well,
at least one piece of it, and just have a resolution addressing the existence of a search committee whose functions are defined in that resolution. Doug?
So try this out. So the first sentence, says it's identifying that there will be the president will take volunteers and create a search committee. All right. And then the second sentence, the committee we can eliminate that, and then the third sentence shall attempt to acquire too, we can eliminate that too, because that'll be in the resolutions. Right. And then the highlighted sentence, the lack of a search committee, I think we should keep that.
Yes.
Okay.
All right. And then, based on, maybe we just eliminate the last sentence as well. The committee shall list, because that's, assuming that's defined in M09. So it really just kind of gives a very high level approach. All right. And pushes for lack of a better term, the operational aspects of the search committee to a resolution, which can be changed much easier than bylaws.
Yeah, and I think not less than 5. I don't think we've had 5 members on the search committee in the time that I've been on the board.
Yeah,
Like three.
yeah.
I think we've had 2 or 3.
Actually, one time when Tom Piatti was there, I think we had Kathy Gallagher, and there were several other. I know we had 4 at least at one point. But
If you go back several years, you'll find very active committees in there.
Okay.
Research committee.
So maybe we can aspire to this again.
Yeah, maybe.
Okay.
But I don't know, does that sound reasonable, Frank? The idea of just, let's remove the,
Let me kind of read. I'm reasonable for anything. The only final thing that I would cast my vote based on is Jeremy saying that has addressed the issue that was brought forth to us in the court judgment. Once we address that,
With respect,
you can
with
write it
respect
in
to
any language.
these potential, with respect to these potential holes here, yes, that will resolve it for this particular language with the.
Okay, so can I read an amended
Please.
motion here? That the search committee no later than February 1st each year, the president shall, subject to confirmation by the board of directors, appoint a search committee of not fewer than 5 members. That's my grammar Nazi in me. Eligible to vote. The committee shall solicit candidates for election to the board of directors. The lack of a search committee or the committee's inability to acquire at least, well, the lack of a search committee will not affect the validity of the election. Okay. Do you accept that friendly amendment, Frank? Jeremy, do you think that covers what we need to do in this?
I think that covers it if we want to keep the search committee as a standing committee, right? If the other option is to say is the president may appoint a search committee to provide those tasks related to the election as decided by the board of directors.
But Jeremy, this does have the board appointing a search committee each year. So it says not later than February 1st each year, the president shall, subject to confirmation by the board of directors, appoint a search committee of not fewer than 5 members of the association eligible to vote. And I think we agreed here as kind of consensus that we like the idea of having an annual appointment of a search committee. We can still define their duties in a resolution.
Okay, can I make a suggestion of 3 to 5 members? Of 3 to 5.
3 to 5, okay.
Can I make another suggestion too? Make it March 1st.
Yes, oh geez, yes, because we're already behind. Okay. Okay, so are we all good with this friendly amendment now? So does anybody second this friendly amendment?
I will.
Doug? Okay.
Final discussion. So March 1st, you're deleting the sentence after one that says the committee shall attempt to acquire at least 2 more candidates. You're deleting that sentence. You're keeping the next sentence to say the lack of search committee won't have an effect on the election, and you're deleting the last sentence that.
And I'm deleting willing volunteers.
And deleting what? Yeah, I saw subject to.
And we're making it 3 to 5 members.
Yeah, 3 to 5 members on March 1st. All right, fine.
Okay. So all in favor of the friendly amendment?
Aye.
Aye.
And all in favor of the motion as amended?
Aye.
Aye.
So that motion passes. And lunch will be on the way in about a half hour.
No problem.
So if we can hang in there till then. Next one, Frank, so we kind of started discussing this, so
Yeah.
we're gonna have to do some friendly amendments on this. You want to go ahead and read it?
Okay, each individual who desires to be a candidate for the election to the board of directors shall complete an application form provided by the association. The candidate must list their full legal name, first, middle, last, including any prefix or suffix, and provide all supporting documentation requested by the application form. The form shall be submitted to the search committee or designated association staff member not later than May 10th and shall state that candidate meets the requirements of paragraph A of this section and is willing to serve as a director if elected. At the candidate's option, the application form may include the candidate's experience, past participation in association governance, and reasons for becoming a candidate.
Is there a second?
I'll second for discussion.
Okay, Doug seconds and discussion. Doug.
So, yeah, I agree with the full name requirement. That's pretty straightforward. I think based on this discussion we had with Jim, the form should be submitted to the search committee. Should we be thinking that the form should be submitted to the secretary?
Yeah.
All right.
Yes.
All right. And then not later.
And I would put the assistant secretary or association secretary, because in effect, it's always been the assistant who's done it.
Here's where I have my question. The form shall state that the candidate meets the requirements of paragraph A. How is he or she going to know that they've met the requirements of paragraph A? In other words, they're just, I believe I've met them, okay? That's certainly, but come to find out later that they haven't met them, okay? So, and there's another provision there, because if you look at M09 that we're talking about, that the secretary is going to get this application, going to look at it, and going to respond back saying, either confirming that the application is complete and up to date, or that additional information is required, okay? So I have trouble with the language, stating that, that it's complete. I guess to the best of my ability, maybe if you add that in there, but, maybe I turn to Jeremy and say, subject to review by the secretary, along those lines. Because, that in and of itself, I follow the rules,
Well, yeah, I see what you're saying.
Jeremy?
I mean, I think that language comes from the current form, which has a certification on it, right? So that they're certifying that basically the information that they're providing is accurate. And so basically that the corporation can rely on that information. I think that's the intent of that provision. Obviously, the secretary would have to do under the other provisions, would do their individual due diligence to verify that. But I think that was the intent of adding that language, was to match what was in the current form, which is to certify it. Does it have just because they say, to answer your question, I think, Doug, just because they say they're qualified doesn't make them so, right?
Correct.
So it doesn't mean that they're qualified just because they say it. It's basically, they're putting in paper that they're affirming that what they're saying is accurate.
Right. So my question is why the language is actually needed. But
yeah,
I don't have a strong
think your comment about, to the best of my knowledge, I meet the requirements.
Yeah, I would be. I mean, it's a little open-ended for me.
Yeah. Would you be more comfortable if it is to the best of my knowledge?
Assuming that we've made changes to 502A already. So as long as that doesn't conflict with the changes that are being proposed for 502A, yes, I would say that. Because that absolves the candidate from, an unknown mistake. In other words, somebody could argue and say, well, it says it right here, you stated that you filled it out. Well, how do I know I filled it out right? I filled it out to the best of my ability, given the information that you gave me.
Yeah, that's to the best of my ability works. But I do think, and I want to address this question more specifically. Rick, I think this addresses the heart of the issue that you brought forth to us, okay? That we need to make our things clear and tighten them up to the point, because, and I'll say this publicly, what I've said privately, I think the simple act of saying on that form that you needed your full legal name would have avoided this whole issue. Okay, and enabled you to clear it up beforehand.
Right.
So, I mean, there's some simple things in these bylaws. I mean, people's hair is on fire and their heads exploding because of the changes, but there are simple things that have existed here for 50 years that we've accepted, that I think that, look, you're a business guy, I'm a business guy. I would never accept an application without a full legal name. We did. It's a mistake. And our rules should prevent us from doing that in the future. Plain and simple.
Did you accept those in your field?
What's that?
Applications without a full legal name.
Well, it all depends. Some people had nicknames that they put on there, preferred names. It all depended on,
But to do a reference check and to do a
if you
background
did,
check,
if
you
you
would
did
need.
an actual reference check or background check, FBI background check, that they would want their legal name
Yeah.
for that.
Yeah, I would just think it would be standard to put it on there.
Yeah, me too.
Regardless, but whatever. Okay, so we have, so may I read this with the friendly amendment I think we put in place? To candidate applications, each individual who desires to be a candidate for election to the Board of Directors shall complete an application form provided for in Resolution M09. The candidate must list their full legal name, first, middle, last, including any prefix or suffix, and provide all supporting documentation requested by the application form. The form shall be submitted to the assistant secretary or the association secretary or assistant secretary not later than May 10th, and shall state that the candidate, to the best of their knowledge, meets the requirements of paragraph A of this section and is willing to serve as a director if elected. At the candidate's option, the application form may include the candidate's experience, past participation in association governance, and reasons for becoming a candidate.
I move for a friendly amendment.
Okay, second.
Second.
And all in favor of the friendly amendment as read?
Aye.
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 All in favor, that passes. All in favor of the motion as amended? Aye.
Aye.
Motion passes.
I'm pretty have to leave. I have a dental appointment.
Okay, thank you so much for being
Thank you,
here and
Jim.
for your,
Thanks, Jim.
for your counsel.
Appreciate your input.
For all your help.
Okay, now we're up to the next one, Frank.
Okay, motion to find candidate eligibility in bylaws, section 5.02D. To have council develop the appropriate wording for referendum to amend and restate section 5.02D by the bylaws as follows. The secretary shall make reasonable efforts to verify that as of May 15th, support each candidate's eligibility and shall submit a list of eligible candidates to the election committee not later than June 1st. If at any time prior to the validation of the election of directors, the secretary determines a candidate does not meet the qualifications to be a candidate for election to the board of directors based on the criteria in section 5.02A, the secretary will deem that candidate to be ineligible to be elected to the board of directors. In such a situation, the association, within 3 business days of the secretary's determination, will publish public notice of such ineligibility determination and basis for the determination. If the election ballots are not printed at the time of the secretary's ineligibility determination, the ineligible candidate's name will be removed from the ballot prior to the distribution to the members. If the election ballots are printed with the ineligible candidate's name, the ineligible candidate's name will remain on the ballot, the election balloting will continue, and all votes tallied and recorded. Votes for the ineligible candidate will not be counted towards determining the candidates who are to be elected. The procedure contained in this paragraph will also be followed if any candidate dies, ceases to be owner of record of real property within the subdivision, or withdraws from the election. The secretary of the election is solely responsible for determining eligibility of a candidate for election to the board of directors and to conduct such referendum. And the purpose and effect is to provide clarity and preciseness to our bylaws.
Second. I'll second.
I mean, guys, from my standpoint, again, to be just perfectly honest and fair, no matter how much honesty and fairness hurts, there was a whole bunch of stuff that we had not had to deal with before, that there were holes in the bylaws that existed for decades. This closes up, I believe, everything that the court has identified.
So again, kind of like, I understand the concept, but I really do have a problem with a couple of things. How do you accurately define reasonable efforts? Because that is a term that's very subjective, okay? You know, hey, I looked at the database, didn't find anything, it's all good, okay? Is that a reasonable effort? I don't want to have language in a bylaw that is open to a subjective interpretation, all right? So I can't support something at reasonable efforts. It needs to be fleshed out a little bit more. And I will tell you that the other thing that bothers me, and it comes from two different perspectives, the last part, the secretary of the association is solely responsible for determining eligibility of a candidate, solely responsible, okay? So that means if that individual somehow has a personal dislike of a candidate, you know, they can, influence, do something that, that would prevent that candidate, from being eligible. I think there should be some level of checks and balances somewhere. Okay, I don't have an answer for you yet, but I'm just saying, when you put that kind of scrutiny on a single individual, it's rife with personal attacks on integrity and so on and so forth. I think in order to protect not only the secretary, but the whole process, there should be some checks and balances in there. And again, I thought it through, and I haven't come up with something that I could offer as a solution just yet, but I will continue to do that if you think this is the way to go. But like I said, I have a tough time swallowing that, because again, it's all about, aversion to risk.
Yeah, but that's how it's been up to this point. It's been on the secretary's shoulders.
Yeah, and
in consultation with council.
And look what's happened.
Well,
Yeah,
it also was again, to Frank's point, the legal name, had it been written accordingly.
This would have happened.
This would have never happened.
Sure,
Had we not had a picture and a name on a membership,
Right,
it never would have happened.
What we're trying to do
But it
is,
happened.
Yeah, but again, in process, okay, checks and balances are important, okay?
Very, yeah.
Single point of failure in any kind of process, mechanical, electrical, provisional, procedural, single point of failure needs to be avoided at any cost, okay?
Right.
And right now, I look at that as a single point of failure. Not from they don't have the capability to do it, but more from a protection perspective, okay?
Well, I think we've covered a lot of this.
All right, well,
Jeremy, what is your thought?
Can I respond to Doug?
Okay.
Let me respond to Doug before Jeremy does, okay? Two points in this thing, Doug, and it comes back to the discussions we've had, because, this hasn't been exactly sprung on us within the last 24 hours.
Right.
The last discussion that Rick and I had with council, okay, I recall I asked Rick, I said, Rick, if you have any questions, I won't put any motions forward regarding eligibility. And we were discussing your issue of, is your name now on the deed in the Worcester County land records? And you said yes.
Mm-hmm.
And Jeremy said, well, they're not there now. And you said, I have a receipt that shows they are. Okay. That's the issue of making reasonable efforts. The secretary could check the land records, okay, which would be reasonable. Okay. She would say, exactly, let's follow the thing that happened in the past. They would say, hey, we don't see you as the owner of record. Rick would say, I have a receipt from Worcester County, which doesn't make Rick or the secretary responsible for Worcester County paperwork. Reasonable efforts, okay, on both parts would be there. As far as the last thing, the secretary of the association is totally responsible. Here's the problem with making anybody else, and I got a zillion different inputs, literally, from the community. The board should make the decision, okay? Let me tell you the reason the board shouldn't make the decision. Upcoming election, up for election, on a cruise and up for election, okay? So there's an issue and you bring it before the board and you're dealing with 3 candidates that are up for election, and I don't think they should have any part in it by law, okay? And that leaves 4 people making the decision on who's going to run, and that doesn't seem to be a good deal either, because there can be divisions. I mean, we can disagree professionally, but we can disagree, okay? So if you toss it back to the board, it makes it exactly what we don't want, which is politicized. In this case right here, it is not a perfect solution, but it takes the politics out of it and it puts it between the secretary, who in the next motion or two has to resign if they're a candidate, and between the attorney and between the GM, none of which would be up for election. That's not a perfect answer, but that's the best one I can give you.
It's not stated in here, okay? the checks and balances. In other words, right, I read that sentence literally, and it says solely responsible. So the scenario you just described, which I agree with in concept, does not make them solely responsible. It includes others, especially if you have the situation where someone who's currently serving as the secretary is going to run for re-election and has to recuse themselves. All right, then who do you go to?
They have to resign, but
Resign as secretary.
Assistant secretary.
All right.
Well, here's
Yeah, and I think
And you don't have to worry about that right now.
Well,
the advantage of that, Doug, is sitting in that chair, that responsibility rests heavily on your shoulders. And when I had a situation where it was legally murky, my best course of action was to get legal advice. That could I have said, no, Jeremy, I think you're wrong. I'm going to do it my way. Certainly I could have done that, but I would have been the one sued.
Right. So,
and I think that that's appropriate.
Well, but again, like I said, solely responsible, to me, that's kind of, it's very sort of focused. All right. The idea would be, solely responsible. If I were to take that literally, then why are you calling Jeremy? I mean, I'm just trying to anticipate somebody's
Solely responsible.
Why are you calling Jeremy? If you're solely responsible, then you shouldn't be talking to anybody to make the decision.
Solely responsible for gathering the information I need to feel confident of my decision, which is what I did. I had legal questions to ask Jeremy. I asked them. He gave me the answer. He didn't tell me what to do. He helped me understand.
Right.
If it's an LLC, what do you do with that?
Okay. Well, we're splitting hairs. You're absolutely right, and I agree with you. I'm just saying is if somebody reads this literally, they're basically saying they'll and let's say there's the the negative connotation of a lot of things. Okay, they'll say, well, now the whole candidate eligibility rests on one individual who may or may like this, and whether it's true or not doesn't matter. Right. Perception's reality, and the idea is, I'm just saying that maybe we ought to consider: is there a solution that will include some sort of checks and balance? Maybe it's the fact that with assistance from legal or something like that.
In consultation with counsel.
And I would just say, Doug, sitting in that chair and having been sued, I would not want to have somebody else's bad judgment. I have to be linked to somebody else who has bad judgment. If I'm going to have bad judgment, I'll own that. But if I'm linked to some other person that I think, geez, that sounds pretty shaky, but they have responsibility too, then I'm stuck with that.
What about the situation where you have bad judgment and it gets
and then I own that.
It gets influenced by somebody who says, no, really, here's what you need to consider, and then you change your tune. That was a benefit right there.
And that's a benefit of consultation with the attorney.
That's what I'm saying. So maybe we should put something in consultation.
No, I agree with that.
Consultation with attorney. I just don't want to hang the secretary out to dry for scrutiny that doesn't necessarily need to be there. And it's only practical to have, when a situation comes up, another, and in this case, I think the most important would be another legal opinion on the situation.
In consultation with counsel sounds fine. However, I do feel that I have to point out, just when you get to the risk thing, okay? I believe it's possible to run into situations where Jeremy may say, there's no good option here. I'm gonna give you 5 options. Okay? Or, to cut to the chase, the judge says, do the right thing. Well, if somebody says there's no good options or do the right thing, it has to go back to the person to determine what they feel the right thing is.
That's right.
Yeah.
There's no
and that's
other.
Where the Colette's concept of owning it comes into play. Okay.
But again, you can only go by what is available as well in a public document. You're going to check SDAT, you're going to go and check the county records, but you can only go by what's updated. And a great example was Frank mentioning, and no disrespect to you, Rick, that the document had not quite been updated yet in the legal documents, and which could then be the same circle that were going around. So maybe the secretary of the association with
in consultation with counsel and public records.
That's
consultation. Right.
That sounds perfect.
I had something.
Yes.
I'm concerned about the reasonable efforts too, because now we've added felons to the list of candidates. So how are we determining the felonies and the probations? And then also, if we're going to remove people because they die or they cease to be an owner of record, we also have to add, possibly, when we get to removal, if they are arrested for a felony or convicted of a felony. We're gonna have to add that language too.
So why don't we just put background check? That would identify all of them.
Well, I think the answer to that is this M09 form has to ask the questions that to support the information required by the bylaws. Okay, that's number one, to do that. Number two, on some of these informations, you won't know. And I think that it is certainly not too far of a stretch of imagination to say that if somebody really had a bad intent, that they could not put some of the stuff down because we don't do the background checks. Okay, but then then I think it's also not too far out of the stretch of imagination to say that although they may think they're operating in a vacuum, really people might be watching them that they're not aware of, and they'll get reported to the general manager. And it'll become aware of the board, and the board can then act, and the secretary can act.
Well, then I think at least we need to add to the second to last paragraph about, whether they're an owner of record or if they withdraw from the election. We have to add something in there about if they're convicted of a felony.
That's why if they're convicted of a felony, okay, let's play through your concern. Look, I mean, let's separate an honest mistake, okay, from an intentional mistake. Okay. There are a lot of honest mistakes that you can make that can be confusing. Okay. And Rick has said, and excuse me for saying this, Rick has said when he filled out the application, he absolutely believed he was qualified under the owner of record. It was, in my opinion, an honest mistake. Okay. I find it hard to believe that you'll be in a state or federal court and a judge will pass sentence on you and that you forget about that as an honest mistake. Okay. But unless you do a background check, and I think that we can have some evidence that can go on for a long period of time and not be known, and you could possibly seat a director. That's why you have removal of a director for a felony. Okay, because they could in fact conceal it intentionally. They could get elected. Okay.
But
And if
they're found ineligible before they're elected, don't we have to add that language in here?
No, the secretary would just declare them ineligible because the information would come up that
But they're found ineligible after the ballots are already out. So the ballots
So
are
we have a
out.
duplicate of what happened this year.
Yeah,
Candidate determined eligible, then oops, made a mistake, candidate not eligible. That is not covered in here.
that language would have to be added.
the candidate is not,
That is deemed to be ineligible after they are certified eligible. Just wait till he responds.
Jeremy, let me ask you a question. I believe in one version of this that got dropped out, it was that could be determined up to and including the last day of the election.
Yes, one of the versions has what happens if eligibility is determined before the ballots go out and after the ballots go out.
Right. And I thought there was a sentence in there that said also at one time, the secretary had that power up to, in fact, the certification of the election.
Yeah, let me look. Let me pull it up.
Oh, here, it's in here.
Yeah, it's in there.
It says if at any
It's in there.
time.
Okay,
It's there.
Yeah.
okay. So
No,
I
this
think-
is if at any time prior to the validation of the election
Yeah.
of directors.
Okay.
Yeah, so it is in there.
So
it's
if
in
your
there.
situation came up, Amy, what would happen is that person would be declared ineligible, okay, up to, I mean, literally the annual meeting.
Mhm.
And their votes would be tallied but not counted in terms of determining the winner. And if that board was seated, okay, based on one of the other amendments that I think we're going to talk about, which is cause for removal, because we added felony and we found out they were a felon after they were seated, after the election was certified, that would be cause for removal, and the board at its determination with a vote of 5 directors could remove them and we would appoint another director.
Doug?
So, we're walking through this. This is the other thing I didn't mention earlier because I wanted to see how the conversation went. But the idea of if at any time the secretary determines, okay? So we got this process that says that the candidate's going to fill out an application. They're going to submit it to the secretary. The secretary is going to deem them eligible, right? All right. And then pass that information along to the elections committee. At that point, the inference is it should stop. But to say at any time infers continuing investigation.
That's my.
All right. So the idea here is like, well, so what happens after you say, you know what, Wheatley is eligible? Okay. You put it in. Is that done? All right. Or am I supposed to continue? If I'm secretary, am I supposed to continue looking for stuff? Because that's open-ended. And I have a problem because it opens up two categories. Number one, there's no finality to the concept of eligibility. In other words, it's been rubber stamped. You're good to go. Okay. We put a stop to the process to the best of our ability. We have made this candidate eligible. Okay. And then down the road, some other piece of information comes up. Too late, Charlie. That should have been brought up when there was an issue of candidate eligibility, when the secretary was doing his or her investigation to determine if the candidate was eligible. So I have a problem with this.
Here, Doug, the secretary shall make reasonable efforts to verify that as of May 15th. But say the guy murders somebody.
Yeah.
After that verification, that's new information. We're not going to expect the secretary to continue to dig. The digging should be done by May 15th.
All right.
But if some other new information comes to light that says, wait a minute, you guys missed
I think it's
something really
important that we
big.
establish some level of finality to the secretary's responsibilities and segregate any additional information that may come from outside sources as something else. Because you don't want to have the secretary saying, "Oh, I certified this candidate is eligible, but I'm going to keep looking."
And so I think that
Right.
that the first paragraph does that. The secretary shall make reasonable efforts to verify that as of May 15th. That means the secretary's work is done.
Okay.
But if information comes in, then that would be if at any time prior to validation of the directors, the secretary determines based on new information brought to them.
And I like the difference, me, the difference between inference and statement.
Right.
Okay? It infers that everything's done on May 15th. Okay. You need to state that everything is done on May 15th. Okay. Yes, the secretary, once eligibility is established, that's it. Okay. State that becomes, de facto standard of eligibility for that particular candidate. Okay. And the only other thing that could influence that would be, the guy goes out and robs a bank. Okay.
Wait a second.
So, wait,
no.
Further information comes to light.
Can I ask a question to
Yeah.
verify? So what you're arguing is fine, Doug. If you're saying is May 15th, either you're eligible or you're ineligible, and that's it, right? And if we find out afterwards that you're ineligible, it doesn't matter with respect to that particular election. You get to keep going.
Is that what you're saying, Doug?
No, that's not what I'm saying. That's not what I'm saying.
So the question is, what are you? The secretary makes the determination. This comes directly from what the judge was saying and what Rick's counsel was arguing over and over again. The secretary's role in determining eligibility after the eligibility date is not defined. Okay. What happens in that interim period if we find out that the candidate was indeed not eligible? For example, we find out that they were convicted in California court of a felony 8 years ago. Right? Okay. There's very unlikely, unless we do a criminal background check, that we would find that out. The question is, what do you do with that information that you have after May 15th? And this amendment that was drafted was an attempt to give a solution to that and give the secretary that authority. If they become aware of information, they would then make that determination to give it to somebody. The alternative is to give it to the board. The alternative is to give it to the board and let the board make the call, which is
I
has
think
pros and cons.
to that.
No.
So Jeremy, this is, again, you don't want anything by inference.
Yeah.
So I would say go on to the next paragraph, and it says, if at any time prior to the validation of the election of directors, the secretary determines based on further information that comes to light, a candidate does not meet the qualifications, blah, blah, blah. You know, so
Fair-
there's an
fair
end
enough.
point of the digging, but if something comes to light, the secretary may then act.
Yeah, and I'm not suggesting that the secretary wouldn't act
Right,
in light of new information.
right.
I just want to make sure that it's not inferred that, this certification is temporary.
Right.
Subject to further disclosure up through until this particular date.
Right.
Okay, because that sends the wrong message.
No, they do their due diligence up to May 15th, assuming,
Right,
and our presumption is that it is their due diligence. But if something comes in, comes to light later,
And-
this is the conversation we had. And that information came to light.
Again, not trying, I mean, I agree with you. Let's move forward. We've been at this a while. But the idea here is how do you vet that information? Suppose it's just a claim,
Well, I mean, then.
And so now, and suppose it takes you a little bit longer to get that information to validate that the information's correct and we've gone past the date. What happens then?
I got a question. What if that, we don't know, I'm the secretary. Miss Amy, bad girl Amy here. We come to find out that it's a sealed case from the US that Amy stole the pair of tennis shoes. I'm just throwing something out there. I'm not gonna find out because that was a sealed case. They are not gonna allow me to have that information until they decide that it doesn't interfere with anything else they got going. Your case in point exactly that, well, when does it start and stop? But I think in a case like that, that would really be the only thing, a felon charge that would allow us to stop that process because of new information that was my 2 cents. But Frank, maybe you want to say something. I don't know.
Well, here's the only thing I can say, Doug, is we can, we're depending on Jeremy, and the reason he saw these multiple times and it just to plug the holes that we know about. Now, let me give you some examples that real life that we've run into, okay? And how I think we can plug the holes going forward. In Rick's case, we've plugged it by addressing the trust. Okay, it was an obvious hole that we had. Okay, we have had other situations where people have advised us, sometimes considerably past an election and even into a second election, that there was a criminal indictment in federal court. Okay, but no sentencing. So let's just say the secretary gets that information. How would they handle it under what we've put forth? The way that the secretary would handle it with common sense and I think consultation with counsel is let the election go on because there's no guilt.
Yeah.
Okay, you're awaiting sentencing.
Yeah.
Okay, the judge hasn't said anything. That the election gets certified. That person is sitting in this room with us. Okay, they are sentenced, right? Under the second one of the amendments that we're looking at that says a director can't be a cause for removal was a felony. We have that covered. But in between, there are any number of legal things going on that we would not be aware of. I mean, literally, unless we had the investigative powers of the Maryland State Police, if it's state, or the Federal Bureau of Investigation, if it's federal. So we can't make it risk-proof, but we can address the situations that we know have put us at risk in the past. And that's all that this is intended to do.
No, I agree. Like I said,
I think we all agree to the same thing.
We all agree.
But
There's
there's a
couple of
gray area.
nebulous things. I don't like the, again, inference versus statement, but I can move forward.
I think we've plugged those inferences up. Can I read an amended or friendly amendment here? So first paragraph is going to stay the same. Second paragraph, first sentence will read, if at any time prior to the validation of the election of directors, the secretary determines based on further information that comes to light, a candidate does not meet the qualifications to be a candidate for election, blah, blah, blah. The rest of that paragraph stays the same. Third paragraph stays the same. Fourth paragraph, the secretary of the association is solely responsible in consultation with counsel and public records when necessary for determining eligibility of a candidate for election to the board of directors.
That's all you got.
Yeah.
Does that sound to you
Sound
good,
good?
Jeremy?
Can I make
Yes,
a few amendments to that?
yes.
Good. So
Yeah.
in the second paragraph, if at any time after May 15th and prior to the validation.
Okay,
15.
anything else?
Do we want to add in, besides consultation with council, consultation with Ocean Pine staff, administrative staff?
Okay,
So with consultation with council and Ocean Pines.
so in consultation with council, Ocean Pines administrative staff, and public records when necessary, and/or public records when necessary. Oh, does that do it for you, Jeremy?
Is it public records with or public records when or if necessary? Public records.
I would say
And public records.
when.
'Cause that's
When
That'd be when.
when the
Yeah.
situation necessitates it.
when
okay.
necessary.
Does that do it for you, Jeremy?
Yes.
Yes? Okay,
Yes.
so we have a friendly amendment. Who would like to second this friendly amendment?
I'll second it.
Okay, Frank Daly. And all in favor of the friendly amendment?
Aye.
Aye. Any opposed? Friendly amendment carries. Now the motion as amended. All in favor of the motion as amended?
Aye.
Anybody opposed? All in favor? Passes. Is lunch here?
It's there.
I think it's on its way.
Okay, so maybe we ought to take a lunch break.
Like a bio break again?
So
Yeah.
30 minutes. Okay, so we're gonna come back to order now. Josh, are you there?
Yes, I'm here.
Great, thank you. Okay, so next amendment is also yours, Frank.
Yes. Okay, here we go. Motion to revise section 5.12C of the bylaws, resignation and removal, felony. To have council develop the appropriate wording for a referendum to amend section 5.12, resignation and removal of the bylaws, to add the following definition for cause as a basis for removal of a director. If the director has been convicted of a felony within 10 years of May 1st of the year in which the candidate was elected, and to conduct such referendum.
Is there a second?
I'll second it, just for
Okay,
discussion.
Okay, discussion?
Hey, one real quick thing, is there a way we can check to see if Rick is online?
Rick, are you there? Do you have his cell phone? Can we text him? Let me see if I have it. I may.
Excuse me, Josh.
I don't see him on the list.
Thank you, sir.
Okay, let me
You bet.
text and see if
You got him?
it's, oops, I'm calling him by mistake. Hi, Rick, it's Colette. Are you ready to come back on? Okay, great. Thanks. Bye. He's gonna open it up right now, so.
Oh my.
Rick, are you on now?
This is Rick.
Great.
Yep, I'm
Okay,
on.
so we're looking at the motion to amend 512C resignation and removal. If the director has been convicted of a felony, we're up to the point of discussing it. Do you have any points of discussion on that?
No, not at this time. Nope.
Doug?
So, two things. One, first of all, more of a question. It's like, if you look at the language, if we've done our due diligence in selecting candidate for eligibility, how can this condition exist?
Yeah, because they can bypass it by accident, and find out
Again, if
after the
it's
fact.
information that comes to
All right.
light later.
And then, I guess for sake of consistency, would we want to consider, doing what we did with
Yes.
the other one?
Yes.
Yeah, I would do
a friendly amendment.
Yeah, I would do a friendly amendment, so it would have the same language as we used on the other one, which eliminates felons for 5 years after all terms are met, including probation, restitution.
Do you accept that friendly amendment?
I do.
Is there a second on that?
Yes, I second.
A second.
Okay. And no further discussion of that friendly amendment. All in favor of the friendly amendment as stated?
Aye.
Any opposed?
Aye.
Okay, all in favor on that one. And then all in favor of the motion as amended?
Aye.
Aye. All in favor. Any opposed? No, so that one passes as well. The next one is.
Motion to revise section 5.12C of the bylaws. I have withdrawn that motion.
Okay. Okay, next one is yours, Frank.
Motion to require resignation of the secretary if running for re-election to the board. To have council develop the appropriate wording for a referendum to amend section 6.03 of the bylaws to add the following. If the secretary intends to be a candidate for re-election to the board of directors in a given year, the secretary shall resign as secretary no later than upon filing of their candidate application, and the board of directors will then elect a new secretary and to conduct said referendum. And this is to provide clarity and preciseness to our bylaws.
Second.
Second.
Okay. Any discussion on this? The only comment I will make is that we have inconsistency of language between candidate application and candidate verification form. MO9 refers to the candidate application as the candidate verification form and a registration form, I'm sorry. So I think in the final analysis, we should just clean up that language.
You can
be fine with that.
Part of the friendly amendment, yeah, or just change the wording.
Okay, so the candidate registration form, I think is.
So instead of application, registration form?
Yeah,
Okay.
so I think it all references in the bylaws, we're gonna need to clean that up. Okay. Any other discussion on this? Okay, all in favor of this motion? Say aye.
Aye.
Aye. Any opposed?
Aye.
Okay, passes. The next one is mine. These are Director, go ahead.
I'm sorry, did Rick oppose or?
He said.
He said aye.
He said aye. Okay, thank you, sir.
So the next group are director duties and responsibilities. So the first one is revision to have council develop appropriate wording for a referendum to revise bylaws section 5.10 to read as follows. Any action required or permitted to be taken by the board of directors may be taken without a meeting as specified in Article 2-408C of the Corporations and Associations article of the Maryland Code. The consent to an action under this section 5.10 shall be reported at the next regular meeting of the board of directors and filed with the minutes of the meeting. This, the purpose and effect is to make our provisions regarding informal actions by directors consistent with the applicable section of the Code of Maryland. And section 2-408C of the Maryland Code reads as follows. Informal action by directors. Any action required or permitted to be taken at a meeting of the board of directors or a committee of the board may be taken without a meeting if a unanimous consent which sets forth the action is given in writing or by electric transmission by each member of the board or committee entitled to vote on the matter and filed in paper or electronic form with the minutes of the proceedings of the board or committee. It is the opinion of the Bylaws and Resolutions Advisory Committee that referencing the language of the Maryland Code lends clarity to the matter and makes our language consistent with state law. Is there a second on this?
Second.
Okay. Any discussion on this?
And just for you, I mean, I'm not picking on you guys, we've been through this and the idea of voting electronically and the idea of unanimous consent. We just want to get it more consistent and per Jim's reference to the Maryland law that it kind of ties it together. Because there was a concern at one point where, what was it, two parts? In other words,
Yeah, we had to vote.
we had to agree to vote by electronic means, and then we had to agree unanimously on the issue. In other words, but now this kind of ties in, it's basically one vote.
One vote.
So, but it's a vote that requires unanimous.
Right, it's unanimous no matter what. So if we try to pass like this motion, we want to do electronically, and somebody opposed, it wouldn't pass, we'd have to take it to a meeting.
Okay. Okay, thank you.
All righty, so that one, any other discussion of this? All in favor of this motion, say aye.
Aye.
Okay, that one passes unanimously. The next one is mine. This is, to have council develop the appropriate wording for a referendum to revise bylaws section 5.11 to read as follows. Members of the board of directors and officers of the association shall not be compensated for services in connection with these positions except as set forth in this section. The board of directors may authorize reimbursement for necessary expenses in connection with service on behalf of the association. Members of the board of directors shall be provided with, in quotes, family membership, end of quote, for all amenities offered by the association. Purpose and effect is to simplify the language of this section. The change is meant to simplify the language and provide for future changes in amenity offerings should they occur. The listing of the amenities, golf, swimming, tennis, paddleball, and beach club parking privileges are stricken from section 511 in this revision in favor of the final sentence above, which replaces it with all amenities offered by the association. Second.
Second.
Okay, and any discussion on this, Amy?
I didn't like this change because I think it left it open for all amenities that a director could say, I want a marina parking spot for my boat. Or I want to be able to, rent out a facility free, because that's an amenity. I thought it was a little too broad, and I kind of liked that it was spelled out before exactly what you got, because I just feel like we're going to get a director who's going to think that they get a boat slip.
Well, Doug.
I was going to say the resource would have to be available. You can't supplant somebody. All right. In other words, and on top of that, it doesn't give you the right to get into the line, the queue that's been up there for 3 years.
I know.
So there's no.
I like that it was spelled out before. There are also other amenities that aren't listed. Like
this is confined to memberships. This is not single use like rental of a room. And I don't think there's a membership to the marina. No. Be swim, whatever the amenities we have right now are, which are swim, racket sports. So it ain't all free racket sports.
It doesn't expand it at all.
No.
Okay. That was my only
provides for. I think there was one that was not listed. Pickleball, because it was a newer sport. Yeah. And so.
So this one went to the work group, to the bylaws committee, and the idea was saying, listen, rather than having to change it 15 different times, if we, we'll just call it family memberships to the amenities and, take it from there, and it just cleans it up. You don't have to worry about it anymore.
Okay, I'm good.
Okay, everybody ready to vote on this?
Yep. Yes, ma'am.
Okay, all in favor, say aye.
Aye.
Yep.
Okay, passes unanimously. Thank you, Rick. The next one is Amy Peck's.
Okay, my motion is to have council develop the appropriate wording for a referendum to revise bylaws section 5.13C as follows. The board may sell, mortgage, encumber, or donate any of the association's real or personal property or assets, but in the event the value of such transaction exceeds 10% of the current income derived from annual charges, it shall require approval of the members by a referendum. The purpose and effect is to limit board authority. The background is that this lowers the percentage from 20% to 10%, giving less power to the board to act without input from the membership. The 10% is in line with the 5/14/21 amendment to 513D1, which limited the board's capital spending to $1 million. There was also a friendly amendment discussion that instead of doing that, we could also do the board may sell, mortgage, encumber, or donate any of the association's real or personal property or assets with the affirmative vote of 2/3 of the entire board of directors. But in the event the value of such transaction exceeds 20% of the current income derived from annual charges, it shall require approval of the members by referendum. So again, this would limit board power as at least 5 board members would need to agree.
And were you inclined to accept the friendly amendment?
If that is, I'm fine with the
Motion.
2/3, yeah.
Okay.
Doug?
Just point of clarification, in your friendly amendment, you mentioned 20%. Did you really mean 10%?
The friendly amendment, I'm with the 2/3, if you want to keep it 20%, I'm okay with that because it's a super majority. If you want to lower it to the 10% to keep it in line with the spending referendum, I'm fine with that too.
We have to second your original motion. Which
Second.
I feel.
Okay.
A second, and then
Okay.
to discussion.
Thank you.
Okay. I also have another friendly amendment to it.
Okay, Frank?
Okay, after the word encumber, add the word develop.
I'm good with that too.
And so what about the, did you have a comment, Doug?
Yeah, I mean, you know me, I like consistency. And if the whole notion, of 20%, we're trying to keep 10% in line with the changes that were made by referendum last year on the 514, I would offer that we should just keep it at 10% to keep things consistent. And
That's what I thought too.
so
I would agree with
I
that.
would ask
I'm
for
fine with that.
consideration from change of friendly amendment to change it from 20 to 10.
Sounds good to me. But with the super majority language.
Yes, the same remains the
Yep.
same.
So it would read,
Do you want me to reread it
Yeah.
for you? The board may sell, mortgage, encumber, or donate any of the association's real or personal property or assets with the affirmative vote of 2/3 of the entire board of directors. But in the event the value of such transaction exceeds 10% of the current value of the current income derived from annual charges, it shall require approval of the members by a referendum.
Develop.
And develop.
But
Sorry.
develop after encumber, no problem.
okay, so is there a second to that friendly amendment?
Second.
And all in favor of the friendly amendment as stated?
Aye.
Aye.
Okay, so the friendly amendment passes affirmatively, unanimously, and then all in favor of the motion as amended, say aye.
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 And the motion passes unanimously. Next one is mine. To have council develop the appropriate wording for a referendum to revise bylaws section 514E to read as follows. Duties. The board shall establish the limits and guidelines applicable to the execution of checks, contracts, and purchases made by the officers of the association, board of directors, and the general manager or management firm in applicable financial policy and procedures manuals. This is to clarify actions to be taken by the board in areas related to financial decisions. This section as currently written could be interpreted to allow for the board to change guidelines, procedures, and even financial institutions from one session to another and lose consistency in policy and procedures. While there are manuals used to avoid this problem, specifying the manuals by file or name could create additional problems if the manuals were updated or superseded by newer volumes. The revisions are meant to clarify and correct the language of this section. Second.
I'll second.
Parks. This was recommended by bylaws and resolutions. Do you have any other background on that, Doug, from your work group?
It was the same thing. It was another reference to the financial policy manual. Like I said, that had been updated since 2006. So
Okay.
just found through the bylaws another reference to that, trying to keep it consistent.
Okay.
Good job.
Okay, so all in favor of this motion?
Aye.
Okay, this passes unanimously as well. The next one is Doug's.
So to have council develop the appropriate language, wording of a referendum to update the wording in section 514. To revise section 514, have to read the board shall designate depositories for the association funds and designate those officers, agents, and employees who shall have the authority to withdraw funds from such accounts on behalf of the association, appropriate financial policy and procedures manual. And the purpose and effect is to clarify the actions taken by the board in areas of financial decision to be consistent with section 514E, which we just passed, okay? And it changes to clarify the correct reference.
Okay, second on that?
Second.
Rick Daly, and any discussion of this? Okay, all in favor of this motion?
Aye.
Any, Rick?
Yeah, aye.
Okay,
In favor.
no opposed, so it passes unanimously. Now we're up to the last of the motions that were in the packet. This is Frank's.
Okay, motion to hold a special meeting for the purpose of revising the charter. Motion to hold a special meeting for the purpose of revising our charter. Purpose and effect to provide clarity and preciseness to our governing documents. Background. The charter may be amended by a vote of 2/3 of the board of directors, provided notice of the board meeting and the proposed amendment to the charter, articles of reinstatement, is provided to the members. The proposed changes are section 5.01, number, term of office, and qualifications. The affairs and business of the association shall be managed by a board of 7 directors, each of whom shall be an owner of record of real property within a subdivision eligible to vote. Additional qualifications for candidacy and election to the board of directors shall be governed by section 5.02A of the bylaws. The terms of the directors shall be for 3 years and until their respective successors are duly elected. No member of the board of directors may be at the same time an employee of the association. The seventh of the charter and 8th of the charter are as follows. The 7 should be corrected to 7, not an 8. Okay. Okay. 7th, there shall be no preference, limitations, or restrictions with respect to relative rights of the members. Notwithstanding, and for clarification purposes, the qualifications for candidacy and election to the board of directors and for service on the board of directors are separate from the rights of members. The 8th paragraph of the charter shall be amended to add the following after existing first sentence. The qualifications for candidacy, election, and service on the board shall be as provided in the bylaws. Okay.
And so the motion is to hold a special meeting for the purpose of revising our charter. Is there a second?
Second.
Okay. And any discussion on this motion?
Just kind of briefly, I mean, okay, let me break down 2 things. The driving force behind this referendum is to address the comments made in the judgment of recent litigation that pointed out deficiencies in our bylaws with regard to candidate eligibility. There are a whole bunch of other things that were added because they were on the list and we wouldn't have a referendum for them to have a referendum and the cost of it, okay? This is the final piece to lock everything together and make that everything precise and consistent. And that is to bring the bylaws and the charter consistent wording with each other. And to do that and to amend that charter, we have to have the special meeting, announce the special meeting, and announce the purpose of the special meeting. And that's what this motion is for.
Okay.
So just sort of some wordsmith correction here. You're referencing subsection 7, okay? And then further subsection 8 of the charter, and there isn't, let me show you the charter here, and I'm trying to figure out which one you are, because there's a section 8 of subsection 6. Which one are you doing here? Because see, if you go to 7, there's only 3 subsections.
Jeremy there? Is Jeremy on board? Jeremy?
I want to get the exact wording that you're referencing.
Jeremy sent this to me for the consistency, so I asked the question of Jeremy.
I don't see him
Yeah,
on the list.
I'm pulling it up.
He's
Hold
on
a
here.
second, please.
Yeah.
Oh, there he is.
There's no subsection 8 of the 7th part of the charter. So and then the 8th is having to do with the changing of the article, really amended, and I just want to make sure I understand which section you are
Oh, absolutely.
referencing here.
So 7th is the board of directors.
Right.
So it'll be to add a. Okay, so it would be. So, sorry, I think I was looking at the old charter. So just to correct it, it would be to add a new paragraph to the First Amendment would be 6th paragraph, added paragraph 10 to add a subsection 10 to paragraph 6
Okay.
of the charter.
That makes sense.
Okay. And then the second one would be add a subsection 4 to paragraph 7.
7, okay. So for sake of clarity, I'd like to request that the published media on this be corrected to reference the correct sections in the
Yes.
in the charter.
So, do you know where those corrections are happening?
Yeah.
Frank?
So
One more time.
section 6.
So what are we striking out here?
Well, so it would be section 6, add a subsection 10, okay?
7th of the charter and 8th of the charter as follows.
Yeah,
That
right.
helps since it's stricken.
No, yeah, just maybe let's start out with what's going to change, and you can decide how to rewrite it.
Okay.
So he's basically saying that under section 6 of the
Okay.
charter, to add a new subsection 10.
Section 6
Right.
of the charter.
Yeah, subsection, add a subsection 10 with the
Charter.
language that you mentioned.
Charter. Add subsection 10.
Right. All right, and then under section 7th of the charter,
Section 7th of the charter.
add a subsection 4.
Section 7th of the charter. Add subsection 4.
4, correct.
Now, okay.
And so the first paragraph down here that says there shall be no preference, limitations, or restrictions is the new 10. Is that correct? Under subsection 6?
No, that's still 9. That's still 9.
That's still 9?
Yeah.
Oh,
Okay,
yeah.
okay. And then the other one, so what is 10, the new 10?
Whatever language you put there.
10 would be the new language.
Under the 6th section of charter, add subsection 10. But what I would suggest on this, Doug, and if this is correct, let me just talk procedurally here for a second. Okay, so we have all these bylaws in front of us, right? Every one of them says to refer them back to council, okay? There's a master copy of these changes that should be kept by the secretary that should go back to council, okay? We are compelled after voting for these to, after at least 15 days, hold a public hearing. So what I'm going to recommend is that these changes with this in it, because before it's the published package, goes back to Jeremy, okay, for rewording to include everything that we've discussed today, that package be reissued to the board, okay? That we have a review of that electronically to make sure that those corrections are in, and then release it to the public.
Okay, so each person who has a motion that needs to be fixed, that person fixes it?
No, it comes from one person, the secretary.
I think that's a lot to put on her. So I think if it's my motion, I should fix the the language that's in there.
Okay.
And if it's your motion, you should fix yours, send it to her and Linda. And Linda, in effect, is going to be the person that sends it on.
It's gonna be sending it to me to
Yeah.
send to you.
Yeah.
Whatever,
I'm fine with
whatever
works.
And I
way
just
works.
want to
I think there
take
should
the
be
burden.
one point of contact though between ultimately Jeremy getting from one person and sending back to one person who distributes to us.
So
Yeah,
Linda, do
typically
you want to be
Linda.
that person or do you want it to be Josette?
No.
Okay,
Agreed.
I think that'll
Thank
be
you.
easier, with.
Yeah.
Okay,
Yes,
so
please. Thank you.
So you retype yours with the friendly amendments, you
Yep.
send them to Linda, and Linda will compile them, send them to Jeremy. And we have one more to write here.
Right.
That Jeremy was gonna offer us some language for.
Right.
So we were amending the agenda, I guess, to add this. Was that the procedure we were gonna use?
We have to have a 2/3 majority to amend the
Amend.
agenda for new business.
Right.
The idea, I believe, what you're referring to is to add and prepare the language for referendum and to develop such referendum for all the motions that didn't have that in the context of the motion
Yes.
form itself.
And wasn't there another motion?
There was another one that was
504 appointees.
to add 504
The
appointees.
qualifications for appointees would be the same as the qualifications for a candidate.
Okay.
And there were no qualifications for candidate that we felt should be excluded from that.
Correct.
Okay, so, so that motion will read to have council develop the appropriate wording for a referendum to update the wording in section 504A. To add, I think, to 504A, a final sentence that read, find 504A. A successor appointee shall meet the same qualifications as a candidate. Does that sound good?
Sounds good to me.
Okay, so there's a few issues we do need to discuss about it really quickly. So
Okay.
So it's gonna have to differ a little bit because you
Okay.
have the qualification for somebody, the ownership eligibility requirement, that January 1st date. And it's of the annual meeting. Here, I think it would be, if we wanted January 1st of the year that the person will be appointed, do we want to have that there? Am I making my explanation clear?
So.
Would have to have been an owner of record.
Yeah.
Yeah, so.
Yes.
So
So
the
which-
owner of record as of January 1st, the year that they were appointed.
Correct.
Right.
I would think that'd be reasonable.
And otherwise meet the eligibility requirements for 502A. This is a little bit different. Because there's no necessarily election for that purpose.
Well, let's not get ahead of ourselves. We haven't voted
Sorry,
yet.
I thought there was a-
No, and otherwise meet the same.
For the charter yet, right?
Same qualifications
Point of order.
as candidate.
I don't mean to disrupt your thought process. If we haven't voted to amend the agenda.
Right, you're right.
Oh, I'm sorry, I thought.
Yeah, so, okay, is there a motion to amend the agenda?
So move.
Is there a second?
Second.
All in favor of amending the agenda, say aye.
Aye.
Okay,
And be advised that you have to require a note that it was 2/3 majority.
And it was unanimous. Is that correct, Rick?
Yeah.
Okay.
Yes.
And so the amendment would be to add a motion to amend the wording of section 504A. No, to have council develop the appropriate wording for a referendum to update the wording in section 504A. To add a sentence that reads,
One more point of order. So now that we have agreed to amend the agenda, okay, you're gonna say, this is what we're going to add to the agenda, and then we have to agree that we accept the agenda as amended. Then we can go
right,
into,
yeah, you're right, skip
then we can
step.
go into that, so.
All right, so let's go through it.
So
I mean,
we
this
have,
is how we're gonna know.
so we have agreed to amend the agenda. Is there a motion to add a motion to the agenda to change the wording of section 504A?
So moved.
Second, Frank Daley. All in favor of a motion to amend 504A? Aye.
Aye.
To accept the amended agenda, sorry.
All right, been running meetings a long time.
I need some caffeine. And I don't usually drink caffeine. So all in favor of accepting the amended agenda?
Aye.
Unanimous. Okay, now we have the motion. So the motion will read to have council develop the appropriate wording for a referendum to update the wording in section 504A to read to add a final one sentence. Owner of record, the candidate, successor appointees shall be the owner of record as of January 1st of the year in which they were to be appointed or are to be appointed, and otherwise meet the same qualifications as a candidate set forth in section 502A.
So moved.
You got that? Okay. Second?
Second.
Okay, it's Amy. And
Amy's number 2.
any discussion?
We agree.
All in favor?
Aye.
Richard?
Aye.
Okay, so that passes unanimously. 502, what was that? 502. 504, you got that?
Yeah.
Okay, so I don't know.
One last cleanup issue, Colette.
Yes.
If you've taken notes regarding any specific motion, I think we should forward them to the person that made the motion, because I made some notes, but when you're talking and discussing something and people are making things, it's easy to miss words and et cetera. And sometimes it's a lot easier if people that have taken the notes during that discussion send it to the director who was in effect leading that discussion to make sure we don't miss anything.
Yeah, I mean, I'll tell myself I wasn't taking notes on if I got any friendly amendments on my motions. I don't think I did.
Yeah, okay. So
And I mean, I have scattered notes.
yeah, so let's send those notes to the person who authored the motion, and then the author correct the motion, circulate it among us before it goes back to Lynn.
Yep.
Okay. Okay, anything else on our agenda today? I think that was it.
But a motion to adjourn.
Motion to adjourn. Second?
Second.
Okay.
I have a time check.
All in favor? It is 1:43. All in favor of
Thank you.
adjourning? Aye.
Aye.
Opposed? We're gonna shoot.
Aye.
Let's take you back and do this.